Wish you had a single lecture explaining everything you need to know in the English law of contract.
Welcome to our marathon lecture on contract law.
Formation of contract requires 5 distinct elements: offer, acceptance, consideration, intention to create legal relations, and certainty. A contractually significant offer is defined as a statement that is certain enough for the other party to accept in its entirety without the need for further discussions. An offer that invites the other party to perform a specific action is a unilateral offer. See for example the case of Carlisle v. Carbolic Smokeball of 1893. An acceptance needs to be an unconditional assent to the terms of the offer and cannot introduce any new terms or make any amendments. A purported acceptance that introduces new terms will not be considered an acceptance that leads to a contract, but a counteroffer, as in Hyde v. Wrench of 1840. Consideration can be defined as an element of value contained in the promises made by the parties. Thomas v. Thomas, 1842. Without this value underlying the promise, the exchange will lack the necessary legal validity to be deemed enforceable in a court of law. The requirement of intention to create legal relations plays a similar role to consideration. The difference between the two is that intention to create legal relations does not rely on concepts of value, but operates on the basis of presumptions to distinguish between social or domestic agreements and commercial agreements. Domestic agreements carry a presumption against enforceability, Balfour v. Balfour, 1919, while commercial agreements carry a presumption in favor of enforceability. The final requirement, certainty, permeates the discussion as to formation of contract, as it works to ensure that the parties have a secure understanding of the contents and aims of their agreement. This first part of this presentation is focused on 2 key elements of contractual formation, that of offer and acceptance. The law of contract is about the enforcement of promises. Not all promises are enforced by courts, however. To enforce a set of promises, or an agreement, courts look for the presence of certain elements. When these elements are present, a court will find that the agreement is a contract. This is a somewhat artificial process. To a certain extent, courts will find that some agreements simply look like contracts and they then reason backward in order to find the elements necessary to form a contract. Be prepared therefore to be initially confused about the link between the law on contract formation and everyday experience of deal-making. To say that we have a contract means that the parties have voluntarily assumed liabilities with regard to each other. The process of agreement begins with an offer. For a contract to be formed, this offer must be unconditionally accepted. The law imposes various requirements as to the communication of the offer and the acceptance. Once there has been a valid communication of the acceptance, the law requires that certain other elements, that we will talk about later on, are present. If these elements are not present, a court will not find that a contract exists between the parties. In the absence of a contract, neither party will be bound to the tentative promises or agreements they have made. It is thus of critical importance to determine whether or not a contract has been formed. We start with discussing the nature of a contractual offer. It is important to understand that it is not the subjective intentions of the parties that determine the legal effect of their words or actions, but how these seem to an external observer. That is to say, the offer is interpreted according to an objective intention. This is, in other words, the interpretation the reasonable person in the position of the offeree would place upon the statement or action of the offerer. This is crucial in answering the basic question, what is an offer? We can say that an offer is an expression of willingness to contract on certain terms. It must be made with the intention that it will become binding upon acceptance. There must be no further negotiations or discussions required. It is very important to realize from the outset that not all communications will be offers. They will lack the necessary intention to be bound upon acceptance. If they are not offers, what are they? At this point, we will distinguish an offer from other steps in the negotiation process. Other steps in the negotiation process might include a statement of intention, a supply of information, or an invitation to treat. Let's see a few of those in turn. A statement of intention, where one party states that he intends to do something. This differs from an offer in that he is not stating that he will do something. An example is the case of Harvey v. Facey, 1893. Similarly, if one party provides information to another party, he supplies the information to enlighten the other party. The statement is not intended to be acted upon. An invitation to treat is an indication of a willingness to conduct business. It is an invitation to make an offer or to commence negotiations. Courts have considered whether or not a communication was an offer or an invitation to treat in a wide variety of circumstances. A display of goods is generally an invitation to treat, and so is an advertisement, as in Partridge v. Crittenden, 1968, and a request for tenders. An auctioneer's request for bids is also an invitation to treat, which means that the bid is an offer. When the auctioneer brings his hammer down, he has accepted the offer. To be effective, an offer must be communicated in the sense that the offeree, the person who will accept, knows of the existence of the offer. There can be no acceptance of the offer without knowledge of the offer. The reason for this requirement is that if we say that a contract is an agreed bargain, there can be no agreement without knowledge. There can be no meeting of the minds if one mind is unaware of the other. Stated another way, an acceptance cannot mirror an offer if the acceptance is made in ignorance of the offer. The authorities are, however, divided on the need to communicate the offer. We now turn to acceptance. For a contract to be formed, there must be an acceptance of the offer. The acceptance must be an agreement to each of the terms of the offer. It is sometimes said that the acceptance must be a mirror image of the offer. The acceptance can be by words or by conduct. Acceptance occurs when the offeree's words or conduct show, to an objective observer, that the offeree assents to the offer as terms. If the offeree attempts to add new terms when accepting, this is a counteroffer and not an acceptance. A counteroffer implies a rejection of the original offer, which is thereby destroyed and cannot subsequently be accepted, as in Hyde v. Wrench, 1840. Where the offeree queries the offer and seeks more information, this is neither an acceptance nor a rejection and the original offer stands. In some cases, the parties will attempt to contract on differing standard forms. In this instance, there will be a battle of the forms with offers and counteroffers passing to and fro. The Court of Appeal has held in Butler Machine Tool v. XLO, 1979, that the last shot wins this battle of the forms. The general rule is that acceptance is not effective until it is communicated to the offerer. This is sometimes expressed by saying that the acceptance cannot be made through silence. The offerer cannot waive communication if that would be to the detriment of the offeree. The general rule is displaced in the case of a unilateral contract. A unilateral contract is one where one party makes an offer to pay another if that other party performs some act or refrains from some act. The other party need make no promise to do the act or refrain from the act. In these cases, acceptance of the offer occurs through performance and there is no need to communicate acceptance in advance of performance. An example of the offer of a unilateral contract is an offer of a reward for the return of a lost cat. In the case of Carlisle v. Carbolic Smokeball Company, 1893, it was established that performance is the acceptance of the offer and there is no need to communicate the attempt to perform. Communication of the acceptance is waived because it would be unreasonable of the offerer to rely on the absence of a communication which would have been unnecessary or which no reasonable person would expect to be made. The rule that an acceptance must be communicated is also waived in the case of the postal acceptance rule. The exception was devised in the case of Adams-Lindsell, 1818. This puts the risk of delay and loss on the offerer. It is important to remember that the rule is an exception to the general rule requiring communication. As modern forms of communication such as fax and email have become almost instantaneous, courts have shown a marked reluctance to extend the postal acceptance rule to these new forms of communication. See, for example, Allianz Insurance Co. Egypt v. Aegeon Insurance County SA, 2008. Offers do not exist indefinitely, open for an indeterminate time awaiting acceptance. For the revocation of an offer to be effective, there must be actual communication of the revocation. It is not necessary for revocation to be communicated by the offerer. Communication to the offeree through a reliable source is sufficient. See for example Manchester Diocesan Council for Education v. Commercial and General Investments, 1970. It seems evident from the information presented already that the fundamental law of contract formation has retained the formalistic character of classical contract law. One could argue, however, that the offer and acceptance paradigm fits poorly with modern contracting practice. Is there still a need for such classical notions to determine contractual deals, especially since other notions, like consideration and intention to create legal relations, seem to cover the same ground, namely determining whether parties wish to be bound in a contract? Think about electronic transactions online. Why do we still need to interpret contractual bargains in this stylistic manner where everything happens at the click of a button? Be that as it may, English courts remain committed to a classical understanding of formation, and there are recent cases to prove it. For example, in Crest Nicholson, Londinium, Limited via Caria Investments Limited, 2010, from November 2010, the court endorsement the traditional approach to determination of formation of contracts, and the distinct tests that will apply to the question of formation and interpretation. This decision emphasizes the necessity for parties to exercise caution when corresponding on matters that amount to an agreement of terms. This means that parties would do well to consider drawing up a simple agreement to reflect agreed terms or variations, rather than to relying on exchanges of correspondence. Be clear and unequivocal when varying contract terms, including expressly stating that other terms remain unaffected, and any suspected mistakes or ambiguities during negotiation should be brought to the attention of the other party as soon as possible, to avoid uncertainty and the potential for dispute at a later stage. It goes without saying that parties to contract negotiations should be aware that emails can create a legally binding contract, dependent on the language used in them, and ensure that they specifically state in any email correspondence whether or not their emails are subject to contract. See Goal and Honor versus Grant and Honor, as joint administrators of Meme SL Limited, 2017. Offers do not exist indefinitely, open for an indeterminate time awaiting acceptance. Indeed, some offers may never be accepted. There is no legal commitment until a contract has been concluded by the acceptance of an offer. Because there is no legal commitment until a contract has been formed, either party may change their mind and withdraw from negotiations. In situations where an offeror has stipulated that the offer will be open for a certain time period, he or she can nevertheless withdraw the offer within this time period. This is called revocation. This will not be the case, however, where the offeror is obliged, by a separate binding collateral contract, to keep the offer open for a specified period of time. For the revocation of an offer to be effective, there must be actual communication of the revocation. It is not necessary for revocation to be communicated by the offeror. Communication to the offeree through a reliable source is sufficient. See for example Manchester Diocesan Council for Education v. Commercial and General Investments, 1970. If the offeree rejects an offer, it is at an end. As would be the case if the offeree makes a counter-offer. Different problems arise when it is the offeree who changes his or her mind. For example, if after posting a letter of acceptance, the offeree informs the offeror by telephone, before the letter arrives, that they reject the offer, should the act of posting an acceptance prevail over the information actually conveyed to the offeror? In the absence of a definitive answer in the case law, the question must therefore be answered primarily as a matter of principle. Treitel suggests that the issue is whether the offeror would be unjustly prejudiced by allowing the offeree to rely on the subsequent revocation. Where the offer is made subject to a condition which is not fulfilled, the offer terminates. The condition may be implied. The death of an offeree normally terminates the offer in that the offeree's personal representatives could not purport to accept the offer. The offeror may also set a time limit for acceptance. Once this time has passed, the offer lapses. In many cases, the offeror can revoke the offer before the time period lapses, provided that the offer has not been accepted. In cases in which no time period is stipulated for the offer, an offeree cannot make an offeror wait forever. The offeror is entitled to assume that acceptance will be made within a reasonable time period or not at all. What a reasonable time period is will depend upon the circumstances of the case. What does one need to do to revoke an offer after it has been communicated? Could one revoke an acceptance sent via non-instantaneous means? Because there is no legal commitment until a contract has been formed, either party may change their mind and withdraw from negotiations. In situations where an offeror has stipulated that the offer will be open for a certain time period, he or she can nevertheless withdraw the offer within this time period. This is called revocation. This will not be the case, however, where the offeror is obliged, by a separate binding collateral contract, to keep the offer open for a specified period of time. For the revocation of an offer to be effective, there must be actual communication of the revocation. It is not necessary for revocation to be communicated by the offeror. Dickinson v. Dodds, 1876. Communication to the offeree through a reliable source is sufficient. See for example Manchester Diocesan Council for Education v. Commercial and General Investments, 1970. The important point is knowledge on the part of the offeree. The means of communication are not critical if the offeree has actual knowledge of the revocation. See Byrne and Company v. Leon van Tienhoven and Co., 1880. It is difficult to preempt acceptance via instantaneous communication. The problem here lies in the postal rule if acceptance is sent via post. The rule was devised in the cases of Adams v. Linsell, 1818, and Household Fire and Carriage Accident Insurance Company Limited v. Grant, 1879. The postal acceptance rule will only prevail in certain circumstances. It will prevail where use of the post was reasonably contemplated by the parties or stipulated by the offerer. However, it was held in Dunmore v. Alexander, 1830, a Scottish case, that postal acceptance can be revoked by faster means of communication. Note, however, that courts will not equate other forms of communication, like email, to the post. Therefore, if one sends an instant message to preempt an email containing an acceptance, this would preempt the acceptance. So far in this presentation, we offered a summary of some of the main aspects of contract formation, especially the function of offer and acceptance. We presented in detail the law in relation to offer and acceptance and discussed the concept of revocation. Now we move on to the next big part of formation, the doctrine of consideration. This concept of consideration is the principal way in which English courts decide whether an agreement that has resulted from the exchange of offer and acceptance should be legally enforceable. It is possible to see consideration as an important indication that the parties intended their agreement to be legally binding as a contract. A quick way to remember what consideration is about is to think whether in any given transaction there has been a promise to give something valuable to the other party. This means something that the other party considers valuable is explained in a moment. In Curry v. Mesa, 1875, it was stated that a valuable consideration, in the sense of the law, may consist either in some right, interest, profit or benefit accruing to the one party, or some forbearance, detriment, loss of responsibility given, suffered or undertaken by the other. English law treats the making of a promise, as distinct from its performance, as capable of being consideration. Thus, in a wholly executory contract, remember that an executory contract is one made by an exchange of promises, and neither party has yet performed. The making of the promise by each side is consideration for the promise made by the other side, so rendering both promises enforceable. Consideration must move from the promisee but not necessarily to the promisor. Remember that the promisor is the person making the promise and the promisee is the person in receipt of this promise. One could promise to pay a sum to a third party, for instance. Also, consideration must be sufficient, but need not be adequate. The requirement that consideration must be sufficient means that what is being put forward must be something which the courts will recognize as legally capable of constituting consideration. The fact that it need not be adequate indicates that the courts are not generally interested in whether there is a match in value between what is being offered by each party. It was established in Chappell v. Nestle, 1960, that a contracting party can stipulate for what consideration he chooses. The courts will not interfere just because it appears that a person has made a bad bargain. An area of particular difficulty relates to promises to perform existing obligations. There are three aspects to this topic, dealing with three different types of existing obligation which may be argued to constitute consideration. These are obligations that arise under the law, obligations owed through contracts with third parties, and obligations owed under existing contracts between the same parties. We start with these obligations which arise under the law, independently of any contract. An example would be a public official agreeing to carry out one or more of their duties in return for a promise of payment from a member of the public. In that situation, the promise of payment will not generally be enforceable. This is either because there is no consideration for the promise, the public official is only carrying out an existing duty, or, more probably, because public policy generally suggests that the law should not encourage opportunities for extortion that enforcing such a promise would create. Where, however, the official does more than is required by the existing obligation, then the promise of payment will be enforceable, as shown by Glassbrick Bros Limited v. Glamorgan C.C., 1925. Next up we have obligations which are owed under a contract with a third party. For those obligations which are owed under a contract with a third party, the position is much more straightforward. The courts have consistently taken the view that this can provide good consideration for a fresh promise. The Privy Council confirmed, in Powon v. Lau Yu Long, 1980, that the promise to perform an existing obligation owed to a third party can constitute good consideration. Remember that the Judicial Committee of the Privy Council originated as the highest court of civil and criminal appeal for the British Empire. It now fulfills the same purpose for many current and former Commonwealth countries, as well as the United Kingdom's overseas territories, Crown dependencies, and military sovereign base areas. Finally, obligations which exist under a contract with a person who has made a new promise, for which the existing obligation is alleged to provide good consideration. This last type of obligation is our entry point into the analysis of the law on contractual modification. It is precisely the area of obligations owed under existing contracts between the same parties that has proved problematic as regards contractual modifications. When you arrange with a builder, for instance, to extend your kitchen outwards into the garden space of your home, you may have agreed a price and building specifications. If your builder asks for an additional fee to complete the work and you agree to pay it, then the question of whether this is a contractually enforceable modification to the contract will come about. If your agreement to pay an extra fee is valid, then the builder could sue you for breach of contract if you fail to provide it. If on the other hand the extra fee is considered an unenforceable promise, a gift, it will be at your discretion. Offer and acceptance are not in issue here. Neither is the intention to create legal relations. We are also certain of the content of the disputed extra payment. The key legal issue is whether the promise to pay extra is supported by consideration. As we said earlier, if a new promise is made while the other party performs an existing obligation, do we have a valid modification to the contract? There is quite a bit of complicated case law that helps us provide an answer to this question. There are two particular cases on this area which you should read carefully: Stilk v. Myrick, 1809, and Williams v. Roffey, 1991. Stilk v. Myrick was long accepted as establishing the principle that the performance of an existing contractual obligation could never be good consideration for a fresh promise from the person to whom the obligation was owed. The Court of Appeal's decision in Williams v. Roffey raised the question of whether Stilk v. Myrick could still be said to be good law. Glidewell L.J. pointed to the practical benefits that would be likely to accrue to the defendants from their promise of the additional money. You should note that Glidewell L.J. summarizes the circumstances where, in his view, the practical benefit approach will apply, which relate very closely to the factual situation before the court and emphasize the need for the absence of economic duress or fraud. Let us look at these cases in some more detail, starting with Stilk v. Myrick. The facts are that the plaintiff had been engaged as part of the crew of a ship, to be paid at £5 a month for a particular voyage. In the course of the voyage, two of the crew deserted, and the captain was unable to replace them. At Kronstadt, he entered into an agreement with the rest of the crew, that they should have the wages of the two who had deserted equally divided among them. The ship was worked back to London by the plaintiff and 8 more of the original crew, with whom the agreement had been made at Kronstadt. On their return, the ship owners refused to pay the additional wages. It was held that the promise to pay the additional money was not enforceable, because there was no consideration for it. Lord Ellenborough stated that there was no consideration for the ulterior pay promised to the mariners who remained with the ship. Before they sailed from London, they had undertaken to do all that they could under all the emergencies of the voyage. They had sold all their services till the voyage should be completed. If they had been at liberty to quit the vessel at Kronstadt, the case would have been quite different, or if the captain had capriciously discharged the 2 men who were wanting, the others might not have been compellable to take the whole duty on themselves, and their agreeing to do so might have been a sufficient consideration for the promise of an advance of wages. But the desertion of a part of the crew is to be considered an emergency of the voyage as much as their death, and those who remain are bound by the terms of their original contract to exert themselves to the utmost to bring the ship in safety to her destined port. Therefore, without looking to the policy of this agreement, the judge thought it was void for want of consideration, and that the plaintiff could only recover at the rate of £5 a month. This case corresponds to the traditional scenario envisaged above, namely, A and B have a contract, and B is having difficulty in performing, or in performing on time. What is the situation if A offers B an additional inducement, probably in the form of extra payment, to complete the contract, or to complete it on time? Is the promise of the inducement enforceable? Has B provided any consideration for it? The general answer given by the classical law of contract is, no, there is no consideration, and the promise is not enforceable. The weakness with all this is that it contradicts the reality of contractual performance. Very often changes need to be made, and are made in good faith. These changes bring a benefit to both parties. For example, one side wins the assurance that the work is completed as envisaged, while the other side secures an additional payment genuinely needed. While this happens in the real world, it does not correspond neatly to the legal construct of the doctrine of consideration. The court struggled in the aftermath of Stilk versus Myrick to bring together theoretical constructs and practical realities. This leads us to a more careful view of the case of Williams v. Roffey.
In contract law, parties need to exchange value. That's consideration. But what happens when someone agrees to pay extra to get a job done that's already under contract? That's exactly what happened in the case of Williams v. Roffey Brothers and Nichols Limited. Let's hear it from the people involved.
I was brought in to do carpentry on 27 flats. The deal was £20,000. Honestly, that wasn't enough once I got into the work. Costs were piling up.
We noticed. You were falling behind, and if you walked off the job, we'd be in breach of our main contract. That meant penalty clauses. Serious money. So we offered you an extra £575 per flat if you could finish on time.
And I agreed. I kept working, pushed through the delays, but then the payment stopped. That extra money never fully came through.
Because, from our point of view, you were already contractual obligated to finish the work. We didn't think there was any legal reason we had to pay more.
The Court of Appeal agreed with Mr. Williams. Even though he wasn't doing anything new, the fact that Roffey Bros got a practical benefit, like avoiding late penalties and disruption, counted as valid consideration. This case redefined the boundaries of contractual promises. It showed that, in some situations, practical benefit is enough to support a variation of a contract, even without fresh obligations.
But you got something out of it. You avoided breach. You didn't have to find a new carpenter. You stayed on schedule. That's a practical benefit, right?
Fair enough. We gained from the arrangement. And that, in law, counts.
Williams v. Roffey Bros in 1991 clarified how courts can treat extra payments and variations. It added a layer of commercial realism to contract law, recognizing value in avoiding trouble.
Lord Justice Glidewell summarized that the present state of the law on this subject can be expressed in the following propositions. If A has entered into a contract with B to do work for, or to supply goods or services to, B in return of payment by B, and at some stage before A has completely performed his obligations under the contract, B has reason to doubt whether A will or will be able to complete his side of the bargain. And if B thereupon promises an additional payment in return for A's promise to perform his contractual obligations on time, and as a result of giving his promise B obtains in practice a benefit or obviates a disbenefit, and B's promise is not given as a result of economic duress or fraud on the part of A, then the benefit to B is capable of being consideration for B's promise, so that the promise will be legally binding. The Court of Appeal was at pains to stress that it was not intending to overrule Stilk versus Myrick, but at the very least, Williams v. Roffey requires a reinterpretation of that case. It is arguable that the captain in Stilk versus Myrick received a practical benefit from the agreement of the crew to continue working. How is this different from the benefit received by the defendant in Williams v. Roffey? In any event, Williams offers a set of criteria in interpreting consideration in a more modern sense. One could say that the only difference between the two cases is the passage of time and a change in judicial attitudes. Further, there is no reason why later courts should be restricted by these criteria in applying the Williams v. Roffey approach. There is a difference, though, between what we could view as positive modifications involving a request for something extra, payment or performance, and negative modifications, involving some lessening of obligations, such as a partial payment. It is important to note at this point that Williams v. Roffey has not affected the related rule that part payment of a debt can never discharge the debtor from the obligation to pay the balance. This rule does not derive from Stilk versus Myrick but from the House of Lords decision in Folkes versus Beer, 1884. The Court of Appeal in Re Select Move, 1995, confined the ambit of the decision in Williams and Roffey as regards to debts. Further, in South Caribbean Trading Limited v. Trafigura, 2004, Justice Coleman doubted the correctness of the decision in Williams v. Roffey. Let us have a closer look to the issue of debt and explain why a partial performance in this case is not accepted as readily as in other cases. The main concern about accepting practical benefit as consideration for a contractual modification becomes apparent if one considers part payment of debts. A part payment of a financial obligation will always be beneficial to the creditor, if the alternative is no payment at all. For this reason, part payment of a debt was never recognized as good consideration in English law. The traditional common law position on the part payment of debts is to be found in Pinnell's case, as confirmed by the House of Lords in Folkes v. Beer. The rule is that part payment of a debt on the date on which it is due can never be satisfaction for the full amount owed. The creditor will still be able to recover the balance of the debt, unless the debtor can show that some consideration was supplied in return for the creditor's agreement to take the lesser sum. In other words, if payment is made early or on the day, but at a different place from that specified in the contract, the debt may be discharged. Equally, if the debtor provides goods or services instead of cash, this, if accepted by the creditor, will discharge the debt fully, even if the value of what was supplied is less than the total amount owed. To use the court's expression, the gift of a horse, a hawk, or a robe, in satisfaction is good. Thus, a payment of £95 on the due date could never discharge a debt of £100, but if the debtor offered and the creditor accepted a book worth £15 in satisfaction, the creditor could not then claim the balance of £75. As it is well known, consideration needs to be sufficient, but not adequate. The court will not second-guess what the parties accept to be valuable. How does one square the introduction of the notion of a practical benefit in Williams with the prohibition on accepting part payment of debts enshrined in Folkes? Luckily, this debate that had stayed rather dormant since Williams v. Roffey came back to English courts in 2016 with a new case of note, MWB Business Exchange Centres Limited v. Rock Advertising Limited, 2016. In Re Sutton, 2014, it was suggested that the provision of a practical benefit, in the form of getting third parties to contribute to the reduced sum that had been agreed with the creditor as settlement for the debt, could be sufficient to make the promise to accept the smaller sum enforceable. In the most recent decision, MWB Business Exchange Centres v. Rock Advertising, however, the Court of Appeal has gone somewhat further. The case concerned a license for the use of business premises. This was renegotiated to give use of larger premises at a higher fee, with the contract to run for 1 year from November 2011. By early 2012, it was clear that the defendants were in difficulties as regards meeting the new higher charge. The claimants subsequently purported to terminate the contract. The defendants argued that an agreement had been made in February 2012 under which the claimants agreed to accept reduced payments for a period, with the balance being made up with larger payments towards the end of the contract. The claimants denied that there was an agreement, but claimed that it would in any case be unenforceable for want of consideration on the Folkes v. Beer principle. The trial judge held that there was an agreement, and that there was sufficient consideration to make it enforceable. On appeal, the Court of Appeal upheld the trial judge's decision. It found that there was sufficient practical benefit to the claimant in the arrangement agreed in February to amount to good consideration for the promise to accept less than was owed. Lord Justice Kitchen, with whom the other two members of the court concurred, noted the claimant's argument that, on the basis of re-select move, there was no room for the Williams v. Roffey concept of practical benefit in this situation, but suggested that this failed to take account of the judge's findings of fact. The trial judge was clearly of the view that the oral variation agreement would have a number of beneficial consequences for MWB. First, MWB would recover some of the arrears immediately and would have some hope of recovering them all in due course. But secondly and importantly, Rock would remain a licensee and continue to occupy the property with the result that it would not be left standing empty for some time at further loss to MWB. There was no suggestion that MWB was under duress in reaching the agreement, and there was commercial advantage to both parties in relation to it. This went beyond the advantage of receiving a prompt but incomplete payment, which was ruled out as being consideration by Folkes v. Beer and re-select move. However, despite the court's insistence that its decision is consistent with both Folkes v. Beer and re-select move, it is difficult to see this case as anything other than a significant limiting of the scope of those decisions, an extension of the scope of Williams v. Roffey. Luckily, the case is proceeded on appeal to the Supreme Court, where the decision reverted to orthodox interpretations of the legal principles. Any discussion of contractual modification would be incomplete, without addressing the doctrine of promissory estoppel. The doctrine of promissory estoppel is intimately linked with the modification of existing contracts. The position under the classical common law of contract was that such modification would only be binding if consideration was supplied and a new contract formed. However, where law goes, equity follows, and the equitable doctrine of promissory estoppel has developed to supplement the common law rules. This allows, in certain circumstances, promises to accept a modified performance of a contract to be binding, even in the absence of consideration. The origin of the modern doctrine of promissory estoppel is to be found in the judgment of Justice Denning, as he then was, in the case of Central London Property Trust Limited v High Trees House Limited, 1947. Estoppel arguably derives from the concept of waiver, which has been recognised by both the common law and equity as a means by which certain rights can be suspended, but then revived by appropriate notice. See, for example, Hughes v Metropolitan Railway, 1877. It was this case upon which Denning J. placed considerable reliance in his decision in High Trees House. Remember, however, that the concept of waiver had not applied to situations of part payment of debts. The doctrine of estoppel has been considered in a number of reported cases since 1947 and now has fairly clearly defined limits. There are a series of key points which must be considered. For a promissory estoppel to operate, the following conditions need to be met according to High Trees. 1. There needs to have been an existing legal relationship. 2. The promise needs to have been relied on. It has sometimes been suggested that this reliance must be detrimental, but Denning consistently rejected this view, and it now seems to be accepted that reliance itself is sufficient. 3. Estoppel can be used as a shield and not a sword. This is related to the first point, concerning the need for an existing relationship. Courts have held that promissory estoppel could not be used as the basis of a cause of action. Its principal use was to provide protection for the promisee. As Lord Denning put it, consideration remains a cardinal necessity of the formation of a contract, though not of its modification or discharge. English courts have resisted attempts to found an action on a promissory estoppel. Note, however, the different approach taken by the High Court of Australia in Walton Stores, Interstate, Limited v. Marr, 1988. 4. It must be inequitable for the promisor to go back on the promise. But what does inequitable mean? It will cover, for example, situations where the promisee has extracted the promise by taking advantage of the promisor. 5. You also need to note that the doctrine is generally suspensory, whereas a contract modification which is supported by consideration will generally be of permanent effect, lasting for the duration of the contract. The same is not true of promissory estoppel. While it is in operation, however, a promissory estoppel may extinguish rights, rather than delay their enforcement. It is accepted that reduced payments made while the estoppel is in operation stand, and the promisor cannot recover the balance that would have been due under the original contract terms. 6. Further, where the promise is prohibited by legislation, an estoppel does not arise. See Evans v. Amicus Healthcare Limited, 2003, for a discussion as to the current state of promissory estoppel and its possible future development. 7. Finally, estoppel rests on the existence of a clear and unambiguous statement. Where the words used to make the statement claimed as the basis for a promissory estoppel were ambiguous and capable of being interpreted in several ways, then the words could not be said to found an estoppel unless the representee sought and obtained clarification of the statement. With this reflection on the consequences of the doctrine of consideration, we move on to some other aspects of formation. These are that the parties intend to create legal relations, that the terms of their agreement are certain and not vague, and that their agreement is a complete agreement that does not need further development or clarification. It is essential that all the parties to an agreement have the intention to create legal relations. What this means is that the parties intend that legal consequences attach to their agreement. In short, the parties intend that the agreement will be binding with recourse to some external adjudicator, a court or arbitrator, for its enforceability. The necessity for intention is most evident in domestic and social agreements. Traditionally, the law has distinguished between domestic and social agreements and commercial agreements. In the case of domestic and social agreements, it is presumed that there is not an intention to create legal relations. In the case of commercial agreements, it is presumed that there is an intention to create legal relations. In either instance, the facts of the case may displace the presumption the law would otherwise make. We will now see in some more detail how all this works. The determination of whether or not the parties intended to enter into legally binding relations is an objective one, and context is all important. What this means is that the courts will not examine the states of mind of the parties to the agreement, meaning that the courts will not take a subjective approach, but will ask whether or not reasonable parties to such an agreement would possess an intention to create legal relations. This objective approach applies regardless of whether the agreement is a social or domestic one or a commercial one. Increasingly, even domestic arrangements are beginning to take on a basis in contract law. See, for example, prenuptial contracts whereby a couple about to be married arranges their financial rights and obligations in case of eventual separation and divorce. On these so-called prenup agreements, there is some more information at the end of the lecture. The key case to note on the topic of intention to create legal relations is Balfour v. Balfour, 1919. This case establishes a rebuttable presumption that domestic agreements are not intended. A rebuttable presumption is a presumption made by courts as to a certain state of facts until the contrary is proved. In Balfour v. Balfour, because the husband would be working overseas, he promised to pay his wife an amount of money each month. When the parties separated, the wife sued the husband for this monthly amount. The court refused to allow her action on the grounds that the agreement was not an enforceable contract because, at the outset of their agreement, it was not intended by either party to be attended by legal consequences, meaning that the parties did not intend that the agreement was one which could be sued upon. The judgment of Atkin L.J. really seems to rest upon public policy arguments, that as a matter of policy, domestic agreements, commonly entered into, are outside the jurisdiction of the courts. His judgment also highlights a judicial concern that if such agreements could be litigated in the courts would soon be overwhelmed by such cases. Similar reasoning was applied in the case of Jones v. Padavatten, 1969, to find that the agreement between a mother and her adult child did not create a contract. See also Coward v. MIB, 1963, where the court found that an agreement to take a friend to work in exchange for petrol money was an arrangement which lacked contractual intention. An example of a situation in which the presumption was rebutted can be found in the decision in Merritt v. Merritt, 1970. Increasingly in the modern world, domestic arrangements are beginning to take on a basis in contract law. While Balfour v. Balfour must be seen as a case which establishes a rebuttable presumption that domestic agreements are not intended, an example of a situation in which the presumption was rebutted can be found in the decision in Merritt v. Merritt, 1970. In this instance, the spouses were already separated and the agreement was found to have an intention to create legal relations. A similar result followed in Dark v. Strout, 2003, where the court found that an agreement for child maintenance following the breakdown of a couple's relationship did not lack an intention to create legal relations given the formality of the letter. Nor could it be said to be unenforceable for want of consideration since the woman had, in entering the agreement, given up statutory rights to maintenance. Also, in Salisbury v. Salisbury, 2007, the Court of Appeal found that there was an intention to create legal relations between two former spouses when one agreed to forego maintenance payments in return for a bequest in the other's will. In relation to commercial agreements, courts will generally presume that an intention to create legal relations is present. See Esso Petroleum Limited v. Commissioners of Custom and Excise, 1976. Of course, it all depends on what one considers as commercial. In President of the Methodist Conference v. Preston, 2013, the Supreme Court held that it was necessary to consider the appointment of a Methodist minister in the context of the factual background. In so doing, the court found that there was no contractual intention. Remember that this objective approach applies regardless of whether the agreement is a social or domestic one or a commercial one. An enforceable contract requires certainty of terms. That is to say, for an agreement to be a contract, it must be apparent what the terms of the contract are. If an important term is not settled, the agreement is not a contract. In Scammell v. Austin, 1941, the court found that the agreement was not enforceable because the terms were uncertain and required further agreement between the parties. Viscount Malm explained that because the terms were uncertain, there was no real agreement, a consensus ad idem, between the parties. The underlying rationale for this area of law can be seen in that if the terms cannot be determined with certainty, there is no contract for the court to interpret. It is not the role of the court to create the terms of the contract, for this would be to impose a contract upon the parties. In some circumstances, particularly where the parties have relied upon an agreement, courts will more readily imply or infer a term. This can be seen in the decision in Hillis v. Arcos, 1932. Here, the agreement had been relied upon and the court was able to infer the intention of the parties based upon the terms in their agreement and the usage in the trade. Similarly, in RTS Flexible Systems Limited v. Molkeray Alois Muller GmbH & Co. KG, 2010, agreement had been reached on all terms of economic significance, and performance commenced. The Supreme Court said that an objective interpretation of the parties' words and deeds suggested that they intended to enter a binding contract despite the fact that certain terms were not yet confirmed. Even if performance is almost complete and the parties throughout confidently expected to agree upon key terms, their actual failure to do so will mean that no contract comes into existence. See British Steel Corp v Cleveland Bridge and Engineering Company Limited, 1984. Related to the requirement of certainty is the requirement of completeness. To create an enforceable contract, parties must reach an agreement on all the major elements of their contract. The agreement must, in other words, be complete. There must be nothing left outstanding to be agreed upon at a later date. Completeness is an aspect of certainty of terms. Unless an agreement is complete, a court is unable to state with certainty what agreement has been made between the parties. If there is no agreement on all of the essential elements of a bargain, there is no contract. There must be an agreement on matters such as price, either by fixing the price or establishing a mechanism to fix the price. What is essential in a contract will depend upon the nature of the contract. There is no such thing as an agreement to agree. The reason for this probably lies in the practical consideration that if the agreement is incomplete, it is not for the court to complete the agreement because the court would then be creating, rather than interpreting, the contract. What is essential in a contract will depend upon the nature of the contract. It is not possible to turn an incomplete bargain into a legally binding contract by merely adding together express and implied terms. Rather, a complete bargain must exist which may be supplemented by further implied terms. See Wells v. Devani, 2016. There is no such thing as an agreement to agree. In Courtney and Fairbairn Limited v. Talani Brothers, Hotels, Limited, 1975, it was held that there was no contract where the parties had simply agreed to negotiate. Their agreement was not enforceable as a contract. In Barbudev v. European Cable Management Bulgaria EOOD, 2012, a communication offering investment on terms to be agreed was said to be no more than an unenforceable agreement to agree. The reason for this probably lies in the practical consideration that if the agreement is incomplete, it is not for the court to complete the agreement because the court would then be creating, rather than interpreting, the contract. In Walford v. Miles, 1992, Lord Ackner noted that the parties to negotiations had diametrically opposed aims and so their opposing interests could not be reconciled sufficiently to support an implied obligation to continue to negotiate in good faith with a particular party. In contrast, an undertaking not to negotiate with third parties, called a lockout agreement, is sufficiently certain to be enforceable. See Pitt v. PHH Asset Management Limited, 1994. The same could be said of an undertaking to use reasonable endeavors to achieve something. Astor Management AG v. Atalaya Mining plc, 2017. It can be seen that in many of the cases between spouses, the usual presumption as to an intention to create legal relations is rebutted after the breakdown of the marriage relationship. A modern development concerns the legal enforceability of an agreement that precedes, rather than follows, the entering of a marriage known as a prenuptial agreement, colloquially a prenup. Historically, it was regarded as contrary to public policy for a couple who were about to get married to make an agreement that provided for the contingency that they might separate. It was thought that an agreement making provision for separation might act as an encouragement to separate. In the past, therefore, such agreements were void and the court would pay no regard to them. In Radmacher v. Granatino, 2010, the Supreme Court upheld a decision that the husband was not entitled to an award of £5.5 million after the breakup of the marriage because such an award would give insufficient weight to the prenuptial agreement. This agreement acknowledged that neither party would acquire any benefit from the other's property during the marriage and its execution was a condition of a substantial transfer of family wealth to the wife. Lady Hale dissented, arguing that there remained important policy considerations sufficient to justify a different approach to agreements made before and after marriage. The decision said, the court should give effect to a nuptial agreement that is freely entered into by each party with a full appreciation of its implications unless in the circumstances prevailing it would not be fair to hold the parties to their agreement. This case offered an answer to the frequently posed question as to the nature of these agreements in English law and whether prenuptial agreements are considered legally binding in England. It is now safe to say that while a prenup in English law is not automatically legally binding, it will be upheld by a court so long as it meets the qualifying criteria of a contract. These criteria, set by the Supreme Court and further reviewed by the Law Commission, are that the agreement must be freely entered into. Both parties must understand the implications of the agreement. the agreement must be fair, contractually valid, made at least 28 days before the wedding and after disclosure about the wider financial circumstances of the parties. Also, both parties must have received legal advice. It is certain that the agreement will not prejudice any children and both parties' needs must be met. Prenuptial agreements are not formally binding in England and Wales. This is in marked contrast to many jurisdictions, including Scotland, the rest of Europe and in most other jurisdictions where prenups are regulated by law and are therefore commonplace. Despite the lack of legally based rules, prenups are regarded by courts as persuasive and often decisive in many applications for financial relief following the breakdown of a marriage. Since the landmark Supreme Court decision in Radmacher v. Granatino, 2010, the use of these agreements in the UK has grown rapidly. To summarize, therefore, in the past it had been questioned whether intention to create legal relations does exist between a married couple, see Balfour v. Balfour, 1919, and whether a couple about to be married could contractually determine their affairs in case of separation in a way that there is certainty over outcomes and an agreement is complete and enforceable should a divorce come about. However, the Radmacher ruling extinguished any doubt that had existed by determining that, from this point onwards, it will be natural to infer that those who enter into a prenuptial agreement intend it be legally binding. Having finished our presentation of the key elements of formation, we can conclude our marathon lecture with an introduction to the concept of privity of contract and the rights of third parties. Privity of contract determines who can enforce a contract. In general terms, only one who is a party to a contract, one who has provided consideration, can enforce it. In many instances, though, privity of contract can defeat the intentions of the parties to a contract and can lead to substantial injustices. For these reasons, many methods have been devised at common law to provide third parties to a contract with a means of circumventing a strict application of the doctrine of privity. The Contracts, Rights of Third Parties, Act 1999 provides parties to a contract with a statutory method of circumventing the doctrine of privity of contract to provide third parties to the contract with a right to enforce contractual terms. The doctrine of privity of contract is primarily concerned with the question of who can enforce a contract. There are two aspects to the doctrine of privity of contract. 1. The first is that only parties to a contract are bound by it. 2. The second is that only the parties to a contract can derive rights and benefits from their contract. At common law, the parties to a contract cannot impose a burden on a third party, nor can they confer a benefit on a third party. See, for example, Tweddle v. Atkinson, 1861. Key cases are Dunlop Pneumatic Tyre v. Selfridge & Co., 1915, Scruttons Limited v. Midland Silicones Limited, 1962, Beswick v. Beswick, 1968. The first aspect of privity, that the parties cannot by their contract impose liabilities or burdens upon a third party, is unobjectionable. The circumstances in which justice calls for such a result are very limited. The second aspect, that the parties cannot benefit a third party to the contract, is however objectionable. There are many situations in which the parties to the contract clearly intend to confer an enforceable benefit upon a third party. The denial of the benefit to the third party defeated the intention of the contracting parties and often produced manifest injustice and commercial inconvenience. The Act implements the recommendations of the Law Commission. Note that it reforms the doctrine of privity, it does not abolish it. The common law devices which circumvented the effects of privity are, therefore, still effective. Under the Act, a third party to a contract can enforce a term of the contract in his own right in two circumstances. 1. Where the contract expressly provides that he may, Section 1(1)(a). 2. Where the terms of the contract purport to confer a benefit upon him and nothing else in the contract denies the purported benefit, Section 1(1)(b), Section 1(2). The right of the third party to enforce a term of the contract is subject to the terms of the contract, Section 1(4). This means that the parties to the contract can impose conditions upon the third party's ability to exercise his rights under the contract. The application of Section 1(3) of the Act was considered in Avramides v. Colwill, 2006. The Court of Appeal held that Section 1(3) required the contract to expressly identify the third party by name or class. The right of the third party is additional to any right that the promisee might have to enforce any term of the contract, Section 4. Generally, the parties to a contract cannot rescind the contract or vary it in such a way as to either 1. Deny the right of the third party, or 2. Alter the entitlement of the third party once the third party has acquired a right to enforce a term of the contract. The third party receives protection from such later changes to the contract in two instances. The first is where the third party has communicated his assent to the term to the promissor. The second is where the promissor is either aware that the third party has relied upon the term, or the promissor can reasonably be expected to have foreseen that the third party would rely upon the term and the third party has relied upon the term. Section 2(1). The Act provides that the contracting parties can provide otherwise in their contract. They can contract to allow a rescission or variation of the contract without the third party's consent, or they can obtain the consent in a different manner than that set out in the Act. Section 2(3). The common law allowed claimants to bypass privity through various mechanisms, including the following: enforcement by the promisee. This is an obvious proposition. It is, essentially, what occurred in Beswick v. Beswick. The estate of the promisee was able to enforce the promise. Two difficulties can arise when the enforcement is to be made by the promisee. 1. The promisee may be unwilling, or unable, to enforce the contract. 2. The second difficulty is to find an appropriate remedy for the third-party beneficiary. The courts have dealt with cases involving third-party rights in the following types of situation: multiple bookings. Jackson v. Horizon Holidays, 1975. Sellers' contracts with carriers to take buyers' goods for delivery. The Albuzero, 1977. Contracts where the subject matter will be acquired by a third party. Linden Gardens Trust v. Leicester Sludge, 1993. An order for the promissor to perform. Beswick v. Beswick. Agency. Agency is not so much an exception to privity as a general commercial necessity. Shanklin Pier Limited v. Detel Products Limited, 1951, is a relevant case. Occasionally legislation uses agency to avoid the difficulties caused by privity. Exemptions and limitations of liability. Courts have stretched the agency concept in one particular situation to provide the third party with the benefit of the exclusion clause in contract. This was established in the Eurymedon, New Zealand Shipping v. Satterthwaite, 1975. Collateral contracts. Occasionally a third party may be made liable on the basis that he has made some promise in consideration of the promisee's entry into the main contract. See Andrews v. Hopkinson, 1957. Trusts. It is possible for the promisee as owner of the promise to constitute a trust of the promise. See Lloyds v. Harper, 1880. Legislation. A statute may overcome the problems that would otherwise be posed by privity. We can see a contemporary application of Section 1(3) of the Act in Chudley v. Clydesdale Bank, 2019. Section 1(3) provides on the rights of a third party to enforce contractual term. The third party must be expressly identified in the contract by name, as a member of a class or as answering a particular description, but need not be in existence when the contract is entered into. Chudley involved a situation where a contract between a bank and an investment company specified how investors' funds were to be held. In these circumstances, the Court of Appeal held that the investors were entitled to sue the bank for breach of contract in their own right under the 1999 Act. The purpose of the contract was to protect investors who, although not expressly named, were sufficiently identified as a member of a class. In contrast, in Bates v. Post Office, No. 3, 2019, assistants working in post offices were not able to bring an action in their own right under the Act. It could not be said that contracts to which sub-postmasters and the post office were parties were entered into for the purpose of training assistants. It seems that the training of assistants was an incidental effect of the contractual performance of the sub-postmasters. One specific area of contemporary significance in relation to third-party rights is data protection. After instruments such as the EU General Data Protection Regulation, known as GDPR, and the California Consumer Privacy Act in the USA, the legal environment governing data has changed significantly, and this affects the rights of third parties under contracts relating to the collection and use of data. As per the GDPR, Article 4, a data controller is the entity, person, organization, etc., that determines the why and the how for processing personal data. A data processor, on the other hand, is the entity that actually performs the data processing on the controller's behalf. In this context, third party means a natural or legal person, public authority, agency or body other than the data subject, controller, processor, and persons who, under the direct authority of the controller or processor, are authorized to process personal data. Other important points include that the third party would be considered a recipient once personal data is disclosed to it, and legitimate interests of third parties can also be used as a legal basis and to justify processing of personal data by the controller where relevant. The consequence of these definitions is that third parties may have responsibilities for the use of data and find themselves subject to liability in ways that transcend our contract law-grounded definitions of rights and liabilities arising from consensual agreements. Anyone working in a field involving data will need to inform themselves of these new frameworks to ensure compliance with this complex set of rules. And, in case you were wondering, the relevance of the EU's GDPR transcends any domestic legal frameworks instituted post-Brexit in the UK. Any discussion on remedies needs to start with an attempt to define what constitutes a breach of contract. A breach of contract can be summarized as the failure of a party to a contract, without a lawful excuse to perform their contractual obligations. An example of a lawful excuse would be frustration. A breach of contract gives rise to secondary obligations, to pay damages, and exceptionally, the party at fault may be forced to perform the obligation by an order of specific performance. A contract can be breached in a variety of ways. Firstly, a party may refuse to perform all or part of the contract. For example, someone refuses to pay for goods received. Secondly, performance would be defective. For example, you order a tablet and it arrives broken. Thirdly, a party may be unable to perform the promised actions. The seller has sold the goods promised to you to someone else. Note, however, the requirement that the failure to perform needs to be without a lawful excuse. If, for example, you refuse to pay for the tablet you ordered because it arrived in an unsatisfactory condition, this may not be a breach, as you may have a lawful excuse. We explore this further towards the end of the lecture, when we discuss the right to terminate. Who needs to prove what happened? The burden of proof is on the party alleging breach. For example, if I think that you have not performed your obligation under the contract terms, I will have to prove it. How can one tell if contractual performance has fallen below what is acceptable? How does one define acceptable? Contractual performance is assessed objectively using two standards, those of strict liability and reasonable care. If with the contract the party guarantees a particular result or to bring about a particular state of affairs, if performance fails short of the stipulated standard, there is a breach even if it is not the fault of the party. It is important to remember that one is not looking for moral culpability, intention, or fault. An illustration is the case of F.W. Moore and Company Limited versus Landauer & Co., 1921, which involved a contract to deliver 3,000 tins of fruit to be packed in cases containing 30 tins each. When some of the consignment was delivered packed in cases of 24, this was held to be a breach of contract. Even though the performance was as valuable as the one promised, it was not what was promised, and the buyer could reject the whole consignment. Note, however, what is known as the de minimis rule, which means that microscopic deviations from the promised performance will not constitute breach, unless they come under a statutory duty to perform absolutely. See Sections 13 to 15 Sale of Goods Act 1979 and Sections 9 to 18 Consumer Rights Act 2015 on obligations as to description, fitness for purpose, satisfactory quality and correspondence with sample in sales of goods contracts. According to these provisions, no matter how slight the deviation, it will be a breach if it comes under the Acts. When the contract does not guarantee the result, then a different standard is adopted, that the party will take reasonable care in carrying out his obligations. An example is Section 13 Supply of Goods and Services Act 1982. Where the supplier is acting in the course of a business, there is an implied term that the supplier will carry out the service with reasonable care and skill. The standard here is still objective because the benchmark is a reasonable person in the trade under consideration. Linked to a discussion on remedies are the consequences termination can have on a contract and the parties. The effect of termination is to release both parties from the performance of obligations which were only due to be performed after the date of termination. Note that termination for breach renders the contract voidable, not void ab initio. The obligation to perform is extinguished, but an obligation to pay damages subsists. The expectation principle is still used as the basis of assessing damages, and the duty to mitigate can in practice sometimes mean that the plaintiff recontracts with the party in breach. The key points about termination are as follows. A breach does not of itself terminate a contract, although all breaches entitle the other party to a remedy. Only some breaches are serious enough to allow the non-breaching party to elect to terminate the contract and seek damages, if appropriate. Terminating a contract is in one sense a form of self-help remedy, because it is a way the innocent party can avoid the consequences of a continued breach without the intervention of the court. However, the innocent party has to be careful, because if she terminates a contract when she is not entitled to do so, then the purported termination will itself be a breach for which they will be potentially liable in damages. In other words, if you terminate the contract when you were not entitled to do so, you are in breach yourself. The other party can terminate and claim remedies from you. We now move on from discussing breach of contract to remedies, starting with damages as the primary remedy for loss. The most commonly used remedy for breach of contract is damages. The aim of damages is to compensate the victim of the breach, not to punish the party in breach. It is for this reason that one will not be able to obtain compensation unless they can demonstrate that they have suffered loss on account of the breach. It is also important to note that the measure of damages is not affected by the motive of the breach. This was illustrated in the case of Addis v. Gramophone, 1909, involving someone's dismissal from their employment. While the claimant did get damages for wrongful dismissal, he could not claim damages for the sharp and oppressive manner in which he was sacked. There are three main headings of damages. 1. Expectation loss, meaning protecting the party's performance interest. 2. Reliance loss, meaning compensating party for what they spent. 3. Restitution, meaning recovering the benefit given to other party. Remember that the difficulty in assessing loss does not mean that the claimant loses his right to damages, unless the loss depends entirely on remote and hypothetical possibilities. For example, in Chaplin v. Hicks, 1911, the difficulty in assessing damages for the loss of a chance to win a beauty contest was not considered a bar to the claim, as real loss had been suffered. We will now consider each of the headings of damages in turn. Awarding damages for expectation loss means compensating the party for the loss of his expectations. What would the party gain from the performance of the contract if the breach had not occurred? In Robinson v. Harmon, 1848, the judge said that the rule of the common law is that where a party sustains a loss by reason of a breach of contract, he is, as far as money can do it, to be placed in the same situation, with respect to damages, as if the contract had been performed. This leads to the next question, which is what to claim and how to claim it. In Parsons Limited v. Utley Ingham and Company Limited, 1978, a farm bought some equipment to store food and used to feed their pigs. Because of the way it was installed, a ventilator was left closed, the feed went bad and the pigs got sick. The claimed compensation was for loss of profits from having lost the pigs. There are a number of ways in which to calculate the loss claimed in such a case. 1. Loss of promised performance, meaning not getting a functioning pig feeder. 2. Consequential loss, which could mean a. the dead pigs, the farm being made worse off. 3. Consequential loss. b. the profits that would have been made from the sale of the pigs have been lost, the farm not being made better off. There are two main measures of damages for expectation loss: difference in value and the cost of cure. Difference in value. A common way to calculate the loss the party suffers from the breach is to determine what the party would earn from the performance of the contract if it had been as promised, and deducting what the party actually got. Promised performance. Actual gain equals amount lost due to breach. Remember that the starting point in determining what will be compensated is that compensation will cover the minimum obligation undertaken. This means that you will receive damages, for example, for the minimum gain you would have made under the contract, not for the eventuality that you might be fantastically successful. This leads us to the next question, which is how do you determine what the party would get? One way is to use the market price rule. What do we mean by market price? The first step is to determine the relevant market. When the seller is offering goods for sale and there is a buyer, the transaction is taken as characteristic of the market. When there is no buyer but there are other traders, information from other transactions can be used to determine the market. The second step is to determine the price. This could be a fair price, determined by actual trade, or the price that people would pay on that day for the goods or services. For example, let us imagine a situation where we agree that I sell you flowers to make flower arrangements. Because the flowers I gave you are substandard, your arrangements are of lesser value. How much money have you lost? What is in this case the relevant market? It would be independent contractors doing that sort of job, meaning sellers of fresh flowers. What is the price? What these people would normally charge for a similar job. In other words, what would be the price of goods similar to those you ordered? However, the difference in value measure may not always be satisfactory. For instance, What if there is no market? For example, when goods are manufactured especially for the buyer, such as a spacecraft made for NASA, there may be no market to discover prices in. In this case, the court itself will estimate the price. Also, what if the goods are defective but are still retained and used by the buyer? There may not be a market for defective goods of that nature. In these cases, it is necessary to consider an alternative ways of assessing damages. Let us discuss the cost of cure. The difference in value measure, as we saw, examines what valuable performance one did receive and how different it is from what one was promised. The cost of cure measure denotes the excess utility, or subjective value, over and above the market value of the performance contracted for, which would have been secured had the contract been properly performed. In other words, the cost of cure measure asks, how can the defective performance be fixed? How can you get what you bargained for? You may think at this point that if differences value is available, the cost of cure is irrelevant. Why bother having different measures? If both measures are available, aren't they the same? The results of calculations could be the same, depending on circumstances. For instance, as in the example above, we agree that I sell you flowers for £5,000 for you to make flower arrangements to sell. Because the flowers I gave you are substandard, worth only £4,000, your arrangements are of reduced value. A diminution in value measure would calculate the price of what you should get minus what you got. 5,000 minus 4,000 equals 1,000. A cost of cure measure would estimate how to fix the problem, meaning bring the flowers up to expected standard. The cost of this may well be 1,000, say to add more quality flowers. So the result would be the same in both cases. But see following. In Jacob and Youngs v. Kent, 1921, work was carried out in a building and the owner wanted the plumbing to be carried out using a specific type of pipes. The builder used another type of pipe that was just as good, but the owner sued in breach of contract. The court said that yes, this is a breach of contract because the performance needs to match the contractual speculation, and it is not up to the builder to substitute the promised items with things he deems just as good. However, awarding the cost of cure would be vastly different from awarding the difference in value. In Tito v. Waddell, No. 2, 1977, a company was granted a license to mine on an island and undertook the obligation to restore the area afterwards. They did not do it and were sued. The diminution in value for plots of land was minimal as the island was not inhabited, but the cost of cure, returning the island to its original condition, would have been huge. The islanders in this case lost. As the differences can be significant then, how does one choose between the two measures? It could be that statute decides. For example, the Landlord and Tenant Act 1927 determines that tenant's covenant to repair is assessed on the basis of diminution in value. The Sale of Goods Act 1979 Section 53(3) says that diminution in value is the measure for defective goods. Also, case law could determine the cost of cure is the appropriate measure for building contracts when reasonable.
In contract law, when something goes wrong, we usually think about compensation. This means an award of money to fix the problem. In this video, we do a deeper dive into contract law and swimming pools. But what if the fix costs more than it's worth? What if it's not practical to make it right? That's the heart of Ruxley Electronics and Construction versus Forsyth, a case that made the courts rethink how they calculate damages.
I hired Ruxley to build a swimming pool in my garden. We agreed it would be 7 feet 6 inches deep. I wanted to be able to dive safely. When they finished, I measured it. It was only 6 feet 9 inches. That's 9 inches short. Not what I paid for.
True, but the pool was still perfectly safe, fully usable. No one's getting hurt diving into that. Fixing it would have meant ripping it all out and starting again. That would have cost over £20,000. For what, a few inches?
It wasn't about inches. It was about what I asked for. I didn't get what I was promised. And don't give me any of that. Size does not matter. It matters what you do with it. I thought I should be compensated enough to rebuild it properly.
Mr. Forsyth sued for the cost of reinstatement. This was over £2,000. But the House of Lords disagreed. They said that kind of expense would be unreasonable and disproportionate to the actual impact. The pool was safe. It worked. The court awarded $2,500 for loss of amenity in recognition that he did lose something, just not enough to justify full rebuilding.
Look, we didn't give him exactly what he asked for, but tearing it up, that'd be wasteful. It's about what's fair, not what's perfect.
I see that now. I still think I deserve the full depth. But I understand courts don't just hand out big sums when there's no real damage.
Ruxley versus Forsyth taught us that damages in contract law aren't just about fulfilling promises. They're about reasonableness, utility, and proportionality. When performance falls short, but the actual impact is small, the courts might award a smaller sum, not the full cost of correction. Loss of amenity matters, even if it's not measured in bricks and bills.
Now you know how courts approach damages in these situations.
We now move on to the second method of calculating damages, that of reliance loss. What is reliance loss? When expectation loss is too speculative, for example, it cannot be proved what you lost from the defective performance, or when you have no loss of profits, you can claim for what you spent in performing your side of the contract. An example is the case of McRae v. Commonwealth Disposals, 1951. The Commonwealth Disposals Commission sold its rights to a tanker that had sunk. It provided the claimant with the details of where the tanker was, and according to the contract, McRae would keep whatever he could salvage. McRae could not find the ship because it was not where the commission said it was. In this case, the claimant could not prove what he lost from the breach because there was no way to tell how much value lay in the tanker. So the only things left to claim were the money paid for the rights to the non-existing tanker and the expenses in mounting the salvage expedition. What can you claim for under the reliance loss heading? It is possible to claim both pre- and post-contractual expenditure, depending on the circumstances. Let us look at pre-contractual expenditure. In Anglia TV versus Reed, 1972, it was held that the case of wrongful repudiation of a contract allowed the aggrieved party may claim by way of damages not only expenditure incurred after contract but also pre-contract expenditure within the reasonable contemplation of the parties. In Anglia, a well-known actor contracted to appear for Anglia Television to play the lead in a play which they were producing. Shortly afterwards, he wrongfully repudiated the contract, and Anglia Television were forced to abandon the production. Anglia Television claimed the total wasted expenditure, but the actor contended that they were entitled only to their expenditure after the contract was concluded. The court found that the plaintiffs could claim expenditure incurred before the contract provided it was reasonably in the contemplation of the parties as likely to be wasted if the contract were broken. It is important to note firstly that Anglia was claiming reliance loss because they could not prove what their profits from the production of the film would have been. Secondly, pre-contractual expenditure can be claimed if it was within the contemplation of the parties. Does the claimant have a completely free choice between expectation and reliance loss? In Anglia, Lord Denning suggested that a claimant needs to make a selection whether he asks for his expectation or reliance loss. This has caused some controversy, but it appears that what Denning meant by this is that the claimant should not be allowed to claim for the same loss twice. Expectation loss will normally involve a claim for gross profits. What would the victim of the breach get from the performance of the contract? This will include already an assessment of the expenses incurred by the claimant. Further, the courts do not offer compensation for the consequences of bad bargains. As in C&P Haulage v. Middleton, 1983, if someone would have lost money out of a deal anyway, they are not entitled to claim the expenses incurred as a result of making the contract. The reason is that this would compensate them at the respondent's expense for the bad bargain they had made and would leave them better off than they would have been had the contract been wholly performed. A significant question that arises from the above is who needs to prove losses? In principle, the claimant is free to quantify his loss on an expectation or on a reliance basis and has to prove the loss he is claiming. However, if the respondent is claiming that this is a bad bargain and it should not be compensated, like in C&P, then the burden of proof shifts to the defendant. Finally, when do we start assessing damages? The usual time for the assessment of the loss is when the performance became due but did not take place. In other words, the relevant time is the date of breach. We now move on to a series of remedies that come under the broad heading of restitution. Restitution, generally defined, allows the victim of breach to recover the benefit passed to the defendant. A difference between restitution and the other two measures, expectation loss and reliance loss, arises in the case of total failure of consideration. In this respect, this can be a more complete measure of compensation because it allows total recovery of the benefit passed to the defendant. Thus, the claimant gets back the value of his performance regardless of whether that is the whole loss. It usually applies to payments of money for nothing in return. What happens, however, if we are not in the domain of total failure yet there is no obvious loss? We have already seen that the principle in Addis v. Gramophone, 1909, is that compensation for breach of contract is for compensating loss, not punishing the defendant or compensating for disappointment. There are, however, cases when the breach results in loss that is not measurable under the two principles mentioned in our discussion of expectation loss, diminution in value and cost of cure. Also, there are cases where the loss is not adequately represented by the use of one of those two measures, because something more is being lost. These cases are known as involving non-pecuniary loss, a loss not measured in money. The general rule is that damages for anguish and vexation were not recoverable when they arise out of a purely commercial contract. Only claims for physical inconvenience, not mere disappointment, have historically been accepted by the courts. An example is the case of Watson and Other versus Morrow, 1991. The plaintiffs, who were husband and wife, acquired a property as a second home and had required that it should be reasonably trouble-free without any need for extensive repairs. The surveyor's report indicated that the defects mentioned in it could be dealt with as part of ordinary maintenance. However, the plaintiffs discovered costly defects beyond those disclosed in the defendant's report. The court found that the financial loss of the plaintiffs was limited to the difference between the value of the property as it was represented to be and its value in its true condition, and also that damages were recoverable for distress and inconvenience caused by physical consequences of the breach of contract. Damages for disappointment will only be recoverable for select cases of special contracts, whose purpose includes pleasure, as for example a holiday contract, see Jarvis v. Swans Tours Limited, 1973. Things become more complicated if one is trying to claim non-pecuniary losses for commercial contracts, given the historical hostility of the courts as mentioned earlier. What happens then when the victim suffers no loss but the defendant is making a profit from the breach? An example is the case of Surrey CC and Mole DC versus Bradero Homes Limited, 1993, where the court held that when a breach of contract caused no loss to the plaintiff, the appropriate award was nominal damages, meaning no compensation of any real value. However, there are some mechanisms that will prevent the perpetrator of a breach from gaining what is seen as an unjust reward. One such mechanism is an account of profits as seen in Attorney General v. Blake, 2001.
Meet George Blake, once a decorated British spy, then double agent.
Agreed.
In 1961, he was convicted of betraying the UK, sentenced to 42 years in prison. He escaped, fled to Moscow, wrote a book, made a profit. But
Right.
the UK government wanted that money back. Could they claim it, even decades later?
Yes. I wrote my story. No other choice, I called it. I told the world how I chose the Soviets. I made around £90,000 from it. Then, they came for my money. Not with handcuffs, but with lawyers.
The government didn't sue for breach of contract alone. They wanted restitution. A
Agreed.
remedy not just for loss, but for unjust enrichment. Usually, when someone breaks a contract, the remedy is compensatory damages, meant to put the claimant in the position
Right.
they would have been in if the contract were performed. But here, the UK had suffered no loss. Still, they argued, he should not profit from his wrong.
They said I owed a fiduciary duty, that I had a special relationship of trust. They claimed my profits were unjust, but I was in Russia, free, or so I thought.
The case reached the House of Lords, and the law lords made history. They held,
Agree.
in exceptional cases, restitution of profits is available for breach of contract. It was rare, but possible. Because of the public
Right.
interest, because Blake had profited by betrayal, because no other remedy would do justice. He had to pay all his book royalties to the Crown.
They couldn't jail me again, but they took the money. They said justice demanded it. Even spies can't profit from secrets.
Attorney General versus Blake reshaped contract law, blending restitution with justice, a spy,
Agree.
a book, a new remedy, and the profits gone in a flash.
Therefore, an account of profits is only considered when no other remedy available. It requires a special relationship between parties, e.g. fiduciary, and the fact that the breach is cynical, deliberate, was made to profit defendant is not enough. The test emerging from Blake is, did the plaintiff have a legitimate interest in preventing the defendant's profit-making activity and depriving him of his profit? A slightly easier way around this problem would be to consider how much money would the plaintiff have asked for to allow the action that now constitutes the breach. This is described as a hypothetical release and illustrated by the case of Rutan Park Estate Company Limited versus Parkside Homes Limited and others, 1974. We now move on to consider remedies other than monetary amounts, meaning damages. As we have seen, damages are the main means of compensation for breach of contract. In exception cases, however, the court may order specific performance. This means order the party in breach to perform the contractual obligation. Specific performance is a remedy at the discretion of the court, only awarded when damages are an inadequate remedy. The burden of proof is on the victim of the breach to establish that damages are not enough to compensate for the loss suffered. Why would damages not be enough? Normally, a monetary amount representing the loss will suffice to cover the loss. However, this assumes that, for instance, the victim of the breach can purchase some substitute performance. When substitute performance is unavailable, one may consider an order of specific performance as the only way to effectively deal with the breach. An example is the case of Sky Petroleum versus VIP Petroleum, 1974. During the oil crisis of the 1970s, the claimant had contracted to buy fuel at fixed prices for a 10-year period. When the respondent wrongfully terminated the contract, the court held that damages would not be enough to compensate. Even though petrol is not unique, since it was difficult to come by during that period, monetary compensation would be inadequate in compensating the claimant for his loss. Could the parties agree on future potential damages? The next part of the discussion deals with this issue. We have discussed in the context of remedies that the purpose of an award of damages is to compensate the victim of the breach for his loss, not to punish the defendant. Is it possible then to have penalty clauses inserted into contracts? Penalty clauses interpreted as a punishment for the contracting party in case of breach of contract will not be enforceable. However, if the clause is interpreted as a liquidated damages clause, it will be enforceable as an assessment of the damage that will arise from the breach of contract. For example, in Dunlop Pneumatic Tyre v. New Garage and Motor Company, 1915, Dunlop was selling tyres to the garage and there was a term in the contract that prohibited the garage from selling them for less than the list price. There was also a clause that if the contract was breached, the garage would pay a fixed amount for each item sold to compensate Dunlop by the way of liquidated damages. The court held that this was an acceptable pre-estimate of the loss and not a clause intended to punish the defendant in case of breach, as a penalty clause. The court highlighted that the label used by the parties for the clause is not conclusive, and that a liquidated damages clause is supposed to be a genuine pre-estimate of damages. Liquidated damages, or agreed damages, are not to be confused with an action for agreed sum. This denotes the situation where the claimant is asking for the contract price after having performed his obligation under the contract. The benefit of this action is that it is not subject to the limiting doctrines we will discuss in a moment. Things like losses of profits we have discussed before are called in the literature consequential losses. How to choose what to include in a damages claim is very important and can have very serious financial consequences. Limitations to the kind of damages available include causation, remoteness, mitigation, contributory negligence and kind of loss, meaning that some types of loss are not available, for example, compensation for mental distress in commercial contracts as we saw above. We will in turn discuss causation, remoteness and mitigation. Causation. Only losses that are causally connected to the breach can be claimed.
So picture this. You've booked a taxi to take you to the airport. It's a big day. You're flying out for a make-or-break business meeting, the kind where you wear a shirt with actual buttons. You book the taxi for 6 a.m. because your flight's at 9 and you're a responsible adult who wants to be at the airport by 7:30, sipping overpriced coffee at the gate. You even confirm the taxi the night before just to be safe. Morning comes, 6 a.m. comes, no taxi. You check your phone, nothing. You call, voicemail. You wait a bit, you call again, still nothing. By now it's 6:40 and you're pacing up and down the street like a character in a rom-com who just got ghosted. Eventually you realize it's not coming. You've been stood up by a taxi. You miss your flight. The meeting. Also missed. Your boss? Not thrilled. In fact, they're so unimpressed they fire you. And to top it all off, your spouse has had enough. They're tired of your career instability and pack their bags. You're now jobless, heartbroken, and questioning all your life choices. Now the big question, Can you sue the taxi company for all this mess? Let's break it down with two big legal ideas: causation and remoteness. Sounds dry, I know, but stick with me. This is where the law steps in and says, okay, that escalated quickly, but how much of that can we actually blame on the taxi? First up is causation, in fact. That's legal speak for, did A actually cause B? In other words, but for the taxi not showing up, would you have missed the flight? Well, no. If the taxi had arrived, you'd have been at the airport, boarding pass in hand. So yes, the missed flight was caused by the taxi's failure. The missed meeting, that happened because you missed the flight. Losing your job, because of the meeting. The marriage breakdown, maybe not directly caused by the taxi, but you could say it played a part. One thing leads to another, and suddenly you're shouting objection at your toaster. But here's the thing. Just because everything technically links together doesn't mean the law will let you claim for all of it. That's where remoteness comes in. This is the legal filter that stops people from suing over consequences that are just too far removed from what actually happened. The classic case here is Hadley v. Baxendale, where the court said you can only claim for losses that either naturally flow from the breach or were in the reasonable contemplation of both parties when the contract was made. So let's apply that to your sad taxi tale. Missing the flight? Totally recoverable. You told them you needed to get to the airport. Everyone knows if you don't get to the airport, you miss the plane. This is basic stuff. If they didn't know you had a flight, maybe it's debatable. But assuming you did tell them, that loss is fair game. The missed meeting is where things start to get wobbly. Unless you said, hey, this flight is for a huge business deal, the taxi company probably wasn't thinking about your corporate ladder ambitions. They just knew you needed a lift. The meeting doesn't arise naturally from the breach, and if it wasn't part of the conversation when the contract was made, it's likely too remote. Losing your job? Definitely remote. The taxi company isn't in charge of your HR file. They couldn't have expected their no-show would lead to your unemployment. Even if your boss said, one more mess up and you're done, the taxi people didn't know that. It's too many steps away. And the divorce? Look, we're sorry. But the courts are not about to pin the collapse of your marriage on a driver with a dodgy alarm clock. Relationships are complex. If we started awarding damages for romantic fallout every time someone missed a ride, there wouldn't be enough lawyers in the world. So where does that leave you? You've got a solid claim for the missed flight, maybe the ticket price, rebooking fees, and any other direct costs. But everything else, the law says no. The missed meeting, the job, the spouse, all just too remote. The law has to draw a line somewhere, and that line usually stops at what's predictable, not what's dramatic. This is why causation and remoteness matter. You can't claim for every domino that falls. Courts want fairness, not infinite liability. They ask, was the result foreseeable? Was it in everyone's minds when the deal was made? In the end, the taxi company might owe you a few £100, but they don't owe you a new job or a couple's counselor. So next time you miss a flight, you can blame the cab, but not for your whole life unraveling.
How much of a connection is needed is explained by the detailed rules on remoteness. Remoteness. The key case on remoteness is the case of Hadley v. Baxendale, 1854. Hadley was the owner of a mill. He contracted with Baxendale for him to carry a part of the machine in the mill to an engineer to fix. Baxendale was late in delivering to the engineer and the mill had to stay closed for an extra 5 days. Hadley claimed loss of profits for the 5 days that the mill was closed. The court held that the resulting loss of profits was too remote a consequence and therefore not recoverable. The court presented the test for allowing consequential loss as a two-part question. I. Is the loss arising naturally from the breach? Or E. Was the loss within the contemplation of the parties? If it arises naturally, then the loss is recoverable. If it does not arise naturally, then the loss is only recoverable if the possibility was known to the parties. But where do you draw the line? A good example is the case of Victoria Laundry, Windsor, v. Newman Industries, 1949. Victoria bought a large boiler from Newman. The boiler was in Newman's shop and had to be disassembled and sent to Victoria. It got seriously damaged during removal and it was 5 months delayed in reaching Victoria. Victoria included in the claim for loss of profits the lost chance of having very lucrative contracts with the Ministry of Supply. The court held that profits from the government contract were too remote. In summarizing the law, the court found the following. The principle of damages is to put the party in the position he would have been, had the contract been performed, expectation loss. This principle pursued without qualification would result, however, in unfairness to the defendant. In cases of breach, therefore, the victim can only recover losses reasonably foreseeable as liable to result from the breach. What is reasonably foreseeable depends on the knowledge of the parties. Knowledge for this purpose is of two kinds. A. Imputed equals reasonable assumption that you can foresee things occurring in the ordinary course of things, first part of Hadley. B. Actual knowledge outside the ordinary course of things, second part. The final limiting doctrine we will discuss is mitigation. Mitigation. The victim of a breach is under an obligation to mitigate his losses. If he fails to do so, then the damages award will be reduced accordingly. This means simply that the breach does not give the victim a license to go and spend. Therefore, the claimant needs to take reasonable steps to minimize his loss, but these steps need only be reasonable. The claimant is not expected, however, to go out of his way to make it easier for the perpetrator of the breach. An example of the rule in operation is the case of British Westinghouse Electric and Manufacturing Company versus Underground Electric Railways Company of London, 1912. But what if one could escape the consequences of breaching a contract through limiting their liability? We now move on to a presentation of limitation of exemption clauses. One of the key elements of the study of the law of contract is the treatment of what are known as limitation, exclusion, or exemption clauses in contracts. These are clauses that try to limit or totally eliminate the liability of a party in case of breach or deviation from contractual performance. In other words, exemption clauses seek to secure one of the parties from liability for losses due to their breach the other party may suffer. A typical clause most of you will be familiar with is one that says, for instance, you are parking your car at this location at your own risk. The parking garage will accept no liability for loss or damage to your vehicle while in our premises. Such a clause may be found in a notification displayed at the location of a car park, or within the terms and conditions of booking of a hotel room, for instance.
Let's say you book a gym membership. You sign up online, tick the box that says, I agree to the terms and conditions, and boom, you're locked into a 12-month contract. A month later, they increase your fees. You complain, and they point to clause 14b of the terms saying they can change prices whenever they want. You never read that clause. Does it matter? Welcome to the world of Incorporation of Terms in contract law. How terms become part of a binding agreement in the first place. There are three main ways terms can be incorporated: by signature, by notice, and by a course of dealing or custom. Then we have implied terms. These don't come from the contract document at all, but are read in by law, custom, or statute. Let's start with the most straightforward method, incorporation by signature. In the famous case of Lestrange versus Graucob, a woman signed a contract for a vending machine. She didn't read the small print, which excluded liability for faults. When the machine broke, she sued. The court said, nope. By signing, she was bound by the terms, even if she hadn't read them. So, if you sign something, you're generally taken to have agreed to all its terms, whether you read them or not. But what if you don't sign anything? That's where incorporation by notice comes in. If a party gives reasonable notice of the terms before or at the time of contract, those terms can still be binding. Take the case of Parker versus Southeastern Railway. A man left his luggage at a railway station. His ticket said, "See back," and on the back was a clause limiting liability. He hadn't read it. The court said it depends. Was reasonable notice of that clause given? In Thornton versus Shoe Lane Parking, Lord Denning was even stricter. A parking garage had an exclusion clause displayed after the customer took the ticket. Denning said it was too late. The contract was formed when the ticket machine spat out the ticket. You can't sneak in terms after the fact. So, timing matters. The more unusual or harsh a term is, the more explicit the notice has to be. If you want to rely on a clause saying, we're not liable for anything, you can't bury it in small print. It needs to be bold, clear, and brought to the other person's attention. Then there's incorporation by a course of dealing, where two parties have done business repeatedly, and the same terms have been used each time. Even if they don't mention the terms in a new contract, a court might find the terms were implicitly agreed based on past behavior. For example, in McCutcheon versus David McBrain, a ferry company sometimes included terms limiting liability. Sometimes they didn't. When they didn't, and a car was lost, the court said the inconsistent practice wasn't enough. There wasn't a clear and regular course of dealing to justify implying the terms. Now let's talk about implied terms. These are different because they're not written or even mentioned by either party. Instead, they're implied by custom, trade usage, or statute. Custom or trade usage means that in certain industries, specific terms are so common that they're just understood. For example, in shipping or commodities trading, everyone knows how risk passes or how delays are handled, even if it's not spelled out. The courts can imply such terms if both parties operate in the same trade, and the usage is well established, reasonable, and certain. But be careful. The courts won't imply custom if it contradicts an express term or if it's too vague. The standard is high. Terms may also be implied by law, especially in certain types of contracts. A great example is in employment law, where terms like mutual trust and confidence, or the right to a safe working environment, are implied whether the contract says so or not. And finally, we have implied terms by statute. This is a major source of consumer protection. Under the Consumer Rights Act 2015, for example, terms are implied into contracts for goods and services. Like the goods must be of satisfactory quality, fit for purpose, and as described. These rights exist automatically and can't be excluded by contract. Similarly, the Sale of Goods Act 1979, for non-consumer sales, implies key terms into contracts for the sale of goods. So to recap, sign a contract? You're bound even if you didn't read it. Given notice of terms before the deal? Those terms are likely in. Repeated dealings on the same terms? Courts may assume they're included. In certain trades, well-known customs can fill in the blanks. And finally, the law itself may step in to implied terms, especially for consumers and employees. Contract law doesn't just care about what's written down. It looks at what was agreed, how, and whether the law thinks it's fair to enforce the term. So next time someone says, it was in the T&Cs, ask, was it really part of the contract?
While the various types of limitation clauses have a negative reputation, it is important to remember that they are legitimate ways to apportion risks of loss between the contractual parties. Consider, for instance, that the costs of obtaining a service could be higher if the supplier was not able to manage the risk of monetary loss arising from customer claims. On the other hand, as most of these types of clauses are inserted in standard form contracts, prepared in advance of meeting the customer, and not subject to negotiation, there is a high risk that they may unbalance the relationship in favor of the supplier of a product or service. This is why there is quite a lot of detailed legislation regulating the form and content of exemption clauses. This part of the presentation will discuss the place of limitation and exemption clauses in English law, presenting their nature and functions, the way the law treats their incorporation into the contract, case law and statutory controls. We touch upon the treatment of such clauses both in the case of consumer and in business-to-business contracts. The presentation starts by discussing how limitation clauses are incorporated into contracts. Addresses their interpretation through the concept of construction. It proceeds to discuss the statutory treatment of potentially unfair terms through the Unfair Contract Terms Act 1977, UCTA, and the Consumer Rights Act 2015, CRA. Exemption clauses may seek to exclude totally a liability or merely to limit it. The terms exemption clause and exclusion clause are often used interchangeably. In this presentation, we also refer to limitation clauses with the same aim. A party wishing to rely on an exemption clause must show that it was a term of the contract, meaning that it was properly incorporated into the contract, and that, properly construed, it covers the loss or damage which has occurred. This is known as construction of the contractual clause. Even if they can show both these things, the clause may still be affected by the Unfair Contract Terms Act or the CRA. We will start by discussing the challenges present in incorporating exemption clauses into contracts. As you have seen in other parts of contract law, express terms, in other words those terms that are chosen by the parties, become part of a contract either via signature on a document or notification. Signed terms are always incorporated, even if harsh or not read or not understood. A good illustration of this rule is the case of Lestrange v. F. Grawcob Limited, 1934. In this case, the buyer of an automatic slot machine signed and handed to the sellers an order form containing in ordinary print and writing the essential terms of the contract, and in small print certain special terms, one of which was, any express or implied condition, statement, or warranty, statutory or otherwise not stated herein, is hereby excluded. The sellers thereupon signed and handed to the buyer a printed order confirmation assenting to the terms in the order form. The machine was delivered by the sellers to the buyer, who paid to the sellers an installment of the price. The machine did not work satisfactorily, and the buyer brought an action against the sellers in the county court claiming, inter alia, damages for breach of an implied warranty that the machine was fit for the purpose for which it was sold. The sellers pleaded, inter alia, that the contract expressly provided for the exclusion of all implied warranties. The buyer replied that at the time when she signed the order form she had not read it and knew nothing of its contents, and that the clause excluding warranties could not easily be read owing to the smallness of the print. There was no evidence of any misrepresentation by the sellers to the buyer as to the terms of the contract. The court held that as the buyer had signed the written contract, and had not been induced to do so by any misrepresentation, she was bound by the terms of the contract, and it was wholly immaterial that she had not read it and did not know its contents, and that the action failed and the sellers were entitled to judgment. A hash judgment, you may think, but one that induces a degree of certainty into deal-making. Signing a document is a definitive demonstration of assent. Unless, of course, there is duress or misrepresentation. In Curtis v. Chemical Cleaning, 1951, when the plaintiff took a white satin dress to the defendant's shop to be cleaned, she was given a paper headed receipt and was asked by a shop assistant to sign it. The plaintiff inquired why her signature was required, and the assistant replied, in effect, that the defendants would not accept liability for certain specific risks, including the risk of damage by or to the beads and sequins with which the dress was trimmed. In fact, the receipt contained a condition that the cleaners accepted no liability for any damage however arising. When the dress was returned to the plaintiff, it was found to be stained, and she was awarded damages by the county court judge, who held that the defendants had been guilty of negligence and were not protected by their exemption clause by reason of misrepresentation as to its character. On appeal by the defendants, the court held that the defendants could not rely on the exemption clause because their assistant, by an innocent misrepresentation, had created a false impression in the mind of the plaintiff as to the extent of the exemption and thereby induced her to sign the receipt. Lord Justice Denning noted that any behavior, by word or conduct, was sufficient to be a misrepresentation if such as to mislead the other party about the existence or extent of the exemption. If it conveyed a false impression, that was enough. Such an impression might even be conveyed by simply handing the document to the customer as if it were a receipt, or by asking her to sign it without drawing attention to the condition. But what if a document is not signed? According to case law such as Chapelton v. Barry UDC, 1940, the document must be something that is recognizable as a contractual document to the reasonable person. Also, the person entering the contract must have had reasonable notice of the term. This last part is quite important, as what constitutes reasonable notice will depend on the circumstances, and crucially the nature of the terms in question. The standard rules on incorporation by notice can be found in cases such as Parker v. South Eastern Railway, 1877, Thompson v. London, Midland and Scotland Railway Co., 1930, Thornton v. Shoe Lane Parking, 1971, and Ollie v. Marlborough Court Hotel, 1949. We will focus here only on those clauses containing particularly onerous terms. As well as the ordinary rules on reasonable notice, special attention must be drawn to any unusual or onerous clause. Lord Denning in Spurling v. Bradshaw, 1956, and Thornton v. Shoe Lane Parking, 1971, picked up later in Interphoto Picture Library v. Stiletto, 1989, created what has become known as the red hand rule, to describe the level of notice one needs to incorporate successfully particularly onerous terms, such as exclusion clauses. In Interphoto, the plaintiffs ran a photographic transparency lending library. Following a telephone inquiry by the defendants, the plaintiffs delivered to them 47 transparencies together with a delivery note containing 9 printed conditions. Condition 2 stipulated that all the transparencies had to be returned within 14 days of delivery, otherwise a holding fee of £5 a day and value-added tax would be charged for each transparency retained thereafter. The defendants, who had not used the plaintiff's services before, did not read the conditions and returned the transparencies 4 weeks later, whereupon the plaintiffs invoiced the defendants for £3,783.50. The defendants refused to pay and the plaintiffs brought an action to recover that sum. The judge gave judgment in favour of the plaintiffs for the amount claimed. On the defendants' appeal, the court held that where clauses incorporated into a contract contained a particularly onerous or unusual condition, the party seeking to enforce that condition had to show that it had been brought fairly and reasonably to the attention of the other party. That, since the plaintiffs had done nothing to draw the defendants' attention to Condition 2, the condition, per Lord Justice Dillon, never became a part of the contract, or, per Lord Justice Bingham, the defendants were relieved from liability under the clause. The red hand rule operates sometimes when a contract term is so harsh, or so wide and destructive of rights, that, in order to give sufficient notice, it would need to be printed in red ink across the front of the document with a red hand pointing to it, or something equally startling. However, even if a term is incorporated properly into the contract, this does not mean that it will be effective. For this to happen, the term will also need to apply to the issue at hand, which brings us to the issue of construction. Saying that you can have a free ice cream if you come by the shop on Tuesday does not entitle you to one if you turn up on Wednesday. This is a silly example, but illustrates that the successful inclusion of a term in a contract will only have consequences to the extent that the clause covers the circumstances of the case. A key question in dealing with exclusion clauses therefore will be whether, once incorporated, the term is properly constructed. In other words, is the clause appropriately worded to cover what has occurred? A key concept in English law is that ambiguous clauses will be interpreted contra proferentum, against the party seeking to rely on them. This is particularly used for exclusion and limitation clauses, but is nonetheless a rule of general application. The burden of proof will be on the person trying to rely on the clause, to convince the court that the clause does in fact operate to limit their liability in the issue at hand. See Andrews v. Singer, 1934. A key illustration of the rule is attempts to exclude liability arising from negligence. The courts have ruled in numerous occasions that especially clear words must be used to exclude this type of liability, but if the contract term expressly mentions negligence, then effect must be given to it. The crucial issue is when there is no express reference, are the words used wide enough to cover negligence? In Canada Steamship Lines Limited v. The King, 1952, the duty of a court in approaching the consideration of clauses which purport to exempt one party to a contract from liability was summarized as follows. 1. If the clause contains language which expressly exempts a, the person in whose favor it is made, from the consequence of the negligence of his own servants, effect must be given to that provision. 2. If there is no express reference to negligence, the court must consider whether the words used are wide enough, in their ordinary meaning, to cover negligence on the part of the servants of A. If a doubt arises at this point, it must be resolved against A. 3. If the words used are wide enough for the above purpose, the court must then consider whether the head of damage may be based on some ground other than that of negligence. The other ground must not be so fanciful or remote that it cannot be supposed to have desired protection against it, but, subject to this qualification, the existence of a possible head of damage other than that of negligence is fatal to her even if the words used are, prima facie, wide enough to cover negligence on the part of his servants. A reference in a contractual document to the contract being subject to general conditions, available on request, is sufficient to incorporate into the contract the terms contained in the current edition of such conditions as in Smith v. South Wales Switchgear County Limited, 1978. But if the clause covers more than one type of liability, it may be taken to refer to non-negligent liability only. In White v. John Warwick & Co., 1953, the plaintiff hired a tradesman's cycle from the defendants. The defendants agreed to maintain the cycle in working order, and Clause 11 of the agreement provided, nothing in this agreement shall render the owners liable for any personal injuries. Quote. While the plaintiff was riding the cycle, the saddle tilted forward, and he was thrown and injured. The court held that, although Clause 11 exempted the defendants, even if they were negligent, from their liability in contract, which was more strict than their liability in tort, it did not exempt them from liability in negligence. If there are two possible heads of liability on the part of a defendant, one for negligence, and the other a strict liability, an exemption clause will be construed, so far as possible, as exempting the defendant only from his strict liability and not as relieving him from his liability for negligence. Finally, Remember that even where an exemption clause has been properly incorporated and even where on its true construction it covers the loss or damage which has occurred, there are still circumstances that may affect its validity, even before we consider the treatment of such clauses as unfair terms. For example, any contractual deal will fail if agreement to the terms has been the consequence of misrepresentation, defined as a false statement of fact that leads the other party to enter into a contract. The Unfair Contract Terms Act 1977 followed unsuccessful attempts by judges to develop common law principles which would control what were commonly regarded as unacceptably harsh exclusion clauses. For a summary of the development of rules about exclusion clauses, see Lord Denning's judgment in George Mitchell v. Finney Lockseeds, 1983. Note that UCTA does not lay down in general terms what is fair and unfair in contracts. UCTA generally applies only to the exclusion or limitation of business liabilities, i.e. liabilities arising in the course of a business, see S.1. In summary, we can say that despite its title, UCTA is not about unfair terms in general. It is, virtually, only about unfair exclusion clauses and limitation clauses. It says that some terms of this type can never be used, but others are rendered ineffective unless they are reasonable. It follows from the above that UCTA does not itself impose obligation on a party, it merely controls attempts to exclude or limit an obligation that would otherwise arise. UCTA amends general common law rules on exclusion and limitation in certain situations, and it can be helpful to think of UCTA and the common law as separate layers, when testing to see whether or not a term is unfair. UCTA divides clauses into three categories: those which are automatically ineffective, those which are effective if reasonable, and those which are unaffected by UCTA. One common error is to think that UCTA subjects all terms to a reasonableness test. It doesn't. Broadly, the effect of UCTA is to render void, or subject to a reasonable test, any clause which purports to exclude or limit liability on the following grounds: liability for the breach of implied terms about the quality of goods and title to them, liability for negligence, contractual or tortious, liability for the breach of express terms, consumer indemnity clauses. Let us now have a closer look at some of the key provisions of the Act. The scope of UCTA is limited in two important ways. Section 1 provides that it only applies to business liability, apart from SS 6 and 8, and Schedule 1 removes certain contracts from its scope, notably insurance contracts and contracts concerning interests in land. UCTA applies mainly to clauses seeking to exclude or limit liability for breach of contract. Liability for negligence arises where there is a breach of a term to take reasonable care, express or implied, for example, Section 13 SGSA 1982, or where an obligation to take care is imposed without a contract, e.g. by the law of tort. UCTA Section 2(1) provides that liability for personal injury resulting from negligence cannot be excluded at all by any contract term. UCTA Section 2(2) provides that liability for other types of loss resulting from negligence can be excluded if the reasonableness requirement is satisfied. This is tested using UCTA Section 11 alongside case law. These are the implied terms as you have seen in different parts of the module, which are based on the Sale of Goods Act 1979 and the Consumer Rights Act 2015 and are implied into the various contracts concerning goods. Clauses which purport to exclude liability for breach of these terms are not effective at all in a consumer contract and are subject to the test of reasonableness, Section 11 and case law, in other types of contract. UCTA is somewhat confusing because it deals with these terms in two sections 6 and 7. To clarify, Section 6 deals with issues about the quality and fitness of goods in sale and hire purchase contracts, while Section 7 deals with them in all other contracts under which possession or ownership of good passes, mainly contracts of hire and where goods and a service are provided together, work and materials contracts. The provisions are identical in their effect, and the only reason there are two sections instead of one is that in 1977 the implied terms dealt with in Section 7 were not derived from statute. They are now contained in the Supply of Goods and Services Act 1982. Section 3 UCTA is a general control of contract clauses. It has two parts, both of which apply to protect consumers, or anyone dealing on another's standard terms. Section 3(2)(a) provides that a clause which excludes or restricts liability for breach is only valid if reasonable. This overlaps with the provisions about implied terms and negligence liability in sections 2, 6 and 7 because those sections already subject such clauses to control. But it also applies where the term breached is an express term, or some implied term not covered by other sections of UCTA. Section 3(2)(b) provides that a clause cannot be an excuse to render a performance different from that which was reasonably expected, or to render no performance at all, unless such a clause is reasonable. The object of the Law Commission, Report Number 69, in including this subsection was to prevent defendants getting round Section 3(2)(a) by claiming that a clause does not restrict liability for breach because the effect of the clause is to leave a particular obligation out of the contract completely so that the question of breach does not or cannot arise. Its potential scope is large, because it makes reasonable expectation rather than a contract term the yardstick of liability. Consumers are treated differently from other contracting parties by sections 3, 4, 6, and 7 of UCTA. It is important to note that for all other sections it does not matter whether the party concerned is a consumer or not. Section 12 defines dealing as consumer. This is defined as a relationship where one party deals in the course of a business and the other does not. Although in most cases it will be obvious whether someone deals as consumer, the meaning of consumer adopted in R&B Customs Brokers v. United Dominion Trust, 1988, means that businesses may sometimes be included. See also Stevenson v. Rogers, 1999. The meaning of reasonableness is something that requires our particular attention. Not all exclusion or limitation clauses are subjected to the test of reasonableness, a common mistaken assumption made by students. Instead, terms should only be so tested when another section of UCTA tells you to do so. The reasonableness test is relevant, and only relevant, under sections 2, 2, 3, 4, 6, 3, 7, 3, and 8. Reasonableness is defined by Section 11 and, in some cases, Schedule 2 may also give guidance. The definition of reasonableness contained in the Act is quite vague, but has been interpreted many times by the courts, so we also need to use case law to help us when looking to see if a term is reasonable. If a term is found to be unreasonable, it will have no effect at all. It will be struck out of the contract and the court will not replace it with a reasonable exclusion clause. The decision in Gill v. Horatio Meyer, 1992, appears to mean that the reasonableness of a term will be judged not just in relation to the claim being brought, but in relation to any claim to which the term could apply. See George Mitchell v. Finney Lockseeds, 1983, for an illustration of the application of the test. The Consumer Rights Act came into force in October 2015. It consolidates and clarifies consumer rights. It does not affect business-to-business contracts, for which the provisions of the Sale of Goods Act 1979, Supply of Goods and Services Act 1982 and the Unfair Contract Terms Act 1977 remain in force as explained in your study guide and textbooks. However, where the contract is made between a business, trader, and a consumer, the law in relation to implied terms and exclusion clauses will undergo fundamental changes to the existing legislation, including the Unfair Terms in Consumer Contracts Regulations 1999, UTCCR, and the Consumer Protection, Distance Selling, Regulations 2000, the DSS. In Part 2, the Act provides a general safety net to prevent unfair terms, reflecting UTCCR provisions and contained in Schedule 2, which are outside the blacklist. In Part 1, Section 63 of Part 2 has a list of terms which may or must be regarded as unfair. This will need to be read in conjunction with S.64, which has a list of terms which cannot be assessed for fairness. In its treatment of what we call unfair terms, the Act moves closer to the European standards of fairness, as opposed to the UCTA language of reasonableness. For example, the reasonableness test from the UCTA is replaced by fairness, including for negligence, which makes it much more in line with the UTCCR. Certain key prohibitions, like the UCTA ban on attempts to exclude liability for death or personal injury, remain. Let us have a closer look at the provisions of the Act. It is worth noting at the outset that building on ECJ, CJEU jurisprudence, see Panan GSM ZRT vs. Erzshay Bet Sustine Gyorfi, 2009, the court can consider unfairness in proceedings of its own motion. Section 71, general definitions are set out in Section 2 of Part 1a. Trader is a person acting for purposes relating to the person's trade, business, craft or profession. A consumer is an individual acting for purposes wholly or mainly outside the individual's trade, business, craft, or profession. A person is not necessarily a consumer. This means that a business is defined much more in line with the principles of the UTTCR. So an incorporated business acting outside its normal course of business cannot fall within this but would need to rely on the existing legislation under the UCTA. Rights under the Consumer Rights Act make it easier to challenge hidden fees and charges. The key terms of a contract, including price, may be assessed for fairness unless they are both prominent and transparent. Terms which are not fair are not automatically binding on the consumer, but one may still rely on them if one chooses to do so. Some examples of terms that may be unfair under the Consumer Rights Act include fees and charges hidden in the small print, a term that tries to limit the consumer's legal rights, disproportionate default charges, excessive early termination charges. Section 62(1) of the CRA 2015 provides that an unfair term in a consumer contract shall not be binding on the consumer, with the test of unfairness is contained in Section 62(4), which states that a term is unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer. A term is unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer. The fairness test thus includes the following main elements: significant imbalance to the detriment of the consumer and good faith. It must, however, be emphasized that the overall requirement is a unitary one. The question is whether a term is unfair. The elements of the test are recognized as being capable of overlapping with each other in their application to any particular set of relevant facts. Significant imbalance is concerned with the parties' rights and obligations under the contract. The requirement is met if a term is so weighted in favor of a business that it tilts the rights and obligations under the contract significantly in its favor, for instance by granting the trader undue discretion or imposing a disadvantageous burden on the consumer. Examples of the types of terms where an unfair imbalance is likely to arise include those that have the effect of restricting or excluding the consumer's normal legal rights, for instance, saying the consumer has no right to seek damages where the trader is at fault, constraining the consumer from seeking the legal remedies to which their rights give rise, for instance, compelling the consumer to take a dispute to arbitration, and imposing on the consumer additional obligations or risks which are not envisaged by law or unreasonably go beyond anything needed to protect the legitimate interests of the trader, for instance, imposing excessive financial sanctions on the consumer for breaching the contract. The above examples come from Schedule 2 to the CRA 2015, consisting of an indicative and illustrative list of terms that may be regarded as unfair, will offer significant guidance as to the application of the unfairness test. The inclusion of a term on the list does not necessarily mean that any clause of that type will be unfair. It will depend on the context in which it is put forward. Neither is the list exhaustive, meaning that a clause of a type that does not appear in it may nevertheless be found to be unfair. The list contains some provisions that are familiar from the controls imposed by the UCTA 1977, such as clauses allowing the seller or supplier to provide inadequate performance or a different product or service from that contracted for. Other provisions reflect the common law rules relating to exclusion clauses, such as the restriction on clauses with which the consumer had no real opportunity of becoming acquainted before the contract. In general, the list is concerned with clauses that allow the seller or supplier to impose on the consumer, for example, by allowing the seller or supplier to cancel the contract without notice, or giving the seller or supplier exclusive rights of interpretation, or requiring the consumer to pay disproportionately high compensation for a breach. It is important to remember that a term or notice that is unfair is not legally binding on consumers. This does not prevent consumers from relying on it if they wish. The Act enables consumers to challenge wording if they consider it unfair and do not wish it to be relied upon as against them. What this means for students of contract law is that the unfair terms legislation now consists of a dual reading of UCTA in the CRA, as opposed to UCTA in the unfair terms in consumer contracts regulations, but the approach remains broadly consistent. The law of obligations has, as is well known, two main branches: that of voluntary agreements, contract, and that which concerns obligations that arise as a result of a duty of care owed, tort. Inherent in the first branch, contract, is the concept of consent. While, however, the concept of consensual bargaining is central to our understanding of contractual obligations, the courts have been reluctant to set aside contracts. This is especially the case when consent is affected by power differentials in contractual bargaining. For instance, it is difficult to set aside contracts between parties of unequal bargaining power solely on the basis of inequality. At the same time, however, courts will not allow the strong to push the weak to extract agreement and, in certain circumstances, courts will set aside apparent contracts. Law and equity develop different responses to the use of illegitimate pressure. Courts of equity would set aside a contract where one party had unduly influenced the other to enter into a transaction. Courts of common law were slower to develop a response to the use of illegitimate pressure but do now recognize, under the doctrine of duress, to render a contract voidable where one party has employed illegitimate pressure during the contractual process. Both duress and undue influence represent situations in which someone has not entered into a contract as a result of their own free will. Their choices have been interfered with in some way, which means that the decision to enter into an agreement has resulted from coercion. Proving that this has occurred, however, is usually difficult, as in some situations the pressure placed on one party by the other can be subtle, and therefore this is one area where presumptions are used as part of the legal arguments establishing a lack of free will. The outcome of successfully arguing that the free will of one party has been coerced is giving the coerced party the freedom to escape the contract, and therefore agreements in this area will be voidable at the discretion of the victim. We deal with these two key ways of addressing lack of propriety in contractual bargaining. We start with a discussion of the doctrine of duress, before moving on to a consideration of undue influence. A key assumption in all discussions on contractual negotiation is that any agreement is the result of a voluntary action of the parties. As mentioned at the beginning of the presentation, generally, courts are reluctant to set aside a contract between parties of unequal bargaining power solely on the basis of inequality. At the same time, however, courts will not allow the strong to push the weak to extract agreement. Who the weak party will be in the types of business contracts we are discussing here will obviously depend on the circumstances. For instance, a landlord will normally be in a stronger position than a tenant in a contract for a domestic tenancy, but the opposite may be true in the case of commercial premises where there may not be a wide range of alternate tenants. As an illustration, consider the frequent use of company voluntary arrangements, CVAs, a controversial form of insolvency being used by a growing number of struggling high street chains. These are employed to entice property owners to accept lower rents to help a tenant avoid financial collapse and are seen by many landlords as attempts by tenants to avoid their rental obligations. Law and equity develop different responses to the use of illegitimate pressure. Courts of equity would set aside a contract where one party had unduly influenced the other to enter into a transaction. Courts of common law, under the doctrine of duress, can render a contract voidable where one party has employed illegitimate pressure during the contractual process. The law encompasses duress to goods and, more recently, economic duress. Duress renders the contract voidable, rather than void. The apparent consent of the victimized party is treated as revocable. They have the ability to affirm or not to affirm the contract. If they choose not to affirm the contract, it is void. See Universe Tankships of Monrovia v. International Transport Workers Federation, the Universe Sentinel, 1983, and Powon v. Lao Yu Long, 1980. The effect of finding that duress renders a contract voidable has several important consequences. For example, the party subject to the duress must act promptly to set aside the contract. See North Ocean Shipping v. Hyundai Construction, 1979, and a third party can acquire good title to goods even though his vendor has acquired those goods pursuant to a contract which was brought about by duress. Initially, only duress to the person, a threat to the personal security of an individual, Barton v. Armstrong, 1976, was recognized as duress. Gradually, the law expanded to encompass duress to goods and, more recently, economic duress. There is even some support for the position that duress renders a contract void amongst the academic commentators, especially when duress is to the person. However, the prevailing view is that duress renders the contract voidable, rather than void. The apparent consent of the victimized party is treated as revocable. Duress to the person occurs when one party to a contract forces another to contract with them through threats of violence. Where a party enters into a contract for several reasons, of which the duress is only one reason, the contract is still voidable. See Barton v. Armstrong, 1976. Duress to goods may occur where one person threatens to destroy or take the goods of another unless a contract is entered into. Duress to goods was recognized in the case of the Ciboen and the Cibotra, 1976. Economic duress as such was recognized in Powon v Lao Yu Long, 1980, and Universe Tankships of Monrovia v International Transport Workers Federation, the Universe Sentinel, 1983. Economic duress occurs when one party uses its superior economic power to force the weaker party into an agreement. The main difficulty in this area is to draw a line between unacceptable commercial pressures, which amount to economic duress, and acceptable commercial pressures, which do not amount to economic duress. Duress exists when there is an illegitimate threat to perform an act unless the other party enters into a contract or varies an existing contract. Consent must be vitiated. Lord Hoffman in R.V. Attorney General for England and Wales, 2003, stated that the wrong of duress had two elements. First, pressure amounting to compulsion of the will of the victim, and, the second was the illegitimacy of the pressure. The difference between acceptable and unacceptable commercial pressures is explained in the speech of Lord Scarman in Powon v Lao Yu Long, 1980. The following are used in determining whether or not there was a coercion of the will such as to vitiate consent. 1. Did the person who was allegedly coerced protest at the time? 2. Did this person have an alternative course of action open to him, such as an adequate legal remedy? 3. Was the person independently advised? 4. Did the person take steps to avoid the contract once they had entered it? CCTN Cash and Carry v. Gallagher, 1994. Let us consider these requirements in a bit more detail. In summary, a finding of economic duress will rest on proving three core elements that 1. A threat was made. 2. The threat was illegitimate. 3. A contract was concluded, but the threat affected the decision-making of the party in the sense that they did not enter into the contract exercising free will. Explaining the threat. First of all, a threat needs to be made. Pressure arising from unfortunate circumstances is not enough. However, threatening to carry out an action that is perfectly lawful would not be seen as forming part of duress. For example, Williams v. Bailey, 1866, concerned a threat of being lawfully imprisoned. D&C Builders v. Rees, 1966, illustrates an illegitimate threat that resulted in the agreement to accept less. In Universe Tankships Inc. of Monrovia v. International Transport Workers Federation, the Universe Sentinel, 1983, a trade union refused to provide tugs to tow certain ships out of harbor unless certain payments were made to its welfare fund. Without the tugs, the vessels would not have been able to sail, and this resulted in the ship being effectively blacked, a term meaning that the trade union's members would not deal with it. They claimed that they were entitled to make such demands because they were protected by the Trade Union and Labor Relations Act 1974. They claimed that the money was extracted as part of a labor dispute, which was protected by the Act. The court held that the availability and eligibility of the welfare fund to employees was not connected to their terms and conditions. Therefore, the union's actions amounted to illegitimate pressure. However, it would be wrong to equate illegitimate with unlawful. In Al Nehayan v. Kent, 2018, the claimant claimed from the respondent amounts due under a promissory note and joint venture agreement. The respondent alleged that his consent to the agreement and the note was obtained by unfair means, including threats of physical violence and economic duress. Leggett L.J. restated the law on duress at quoting Times Travel, UK, Limited v. Pakistan International Airlines Corp., 2017. There can be no doubt that even a threat to commit what would otherwise be a perfectly lawful act may be improper if the threat is coupled with a demand which goes substantially beyond what is normal or legitimate in commercial arrangements. There is no reason the distinction between lawful and unlawful behavior should be decisive of whether the respondent can retain money or other benefits demanded from a claimant in a situation of extreme vulnerability. It is appropriate to take account of the legitimacy of the demand and to judge the propriety of the defendant's conduct by reference not simply to what is lawful but to basic minimum standards of acceptable behavior. In summary, therefore, a demand coupled with a threat to commit a lawful act will be regarded as illegitimate if a. The defendant has no reasonable grounds for making the demand and b. The threat would not be considered by reasonable and honest people to be a proper means of reinforcing the demand. The doctrine of duress could be interpreted as being based not on lack of consent but on showing that a party's consent was obtained in circumstances which make it unjust to allow the other party to enforce the agreement. Therefore, that legal advice was taken or rational or independent judgment exercised in entering into a contract does not preclude a finding of duress. What is necessary is that the illegitimate pressure caused the claimant to enter into the contract. As to causation, a threat of violence causes a party to enter a contract if it is a reason for entering it. With economic duress, the but for test applies. It is not necessary that the claimant had no reasonable alternative to giving in to the illegitimate pressure. What is required is very strong evidence of whether the claimant was induced by the threat or other illegitimate pressure to enter into the contract. This is also a relevant factor in deciding whether use of pressure was illegitimate even though there is no illegality. Examining the contract, there has to be an effect seen as a result of the threat. If duress is about showing the will of one of the parties has been subverted in some way, there has to be a link between the decision to enter the contract and the threat made. In Barton v. Armstrong, 1976, a former chairman of a company threatened the managing director with death if he did not transfer his share of the company for a large sum of money. However, the argument in court to strike out the transaction for duress failed, because there was some evidence that the managing director believed this to be a good deal and, although he felt apprehensive about himself and his family's safety, this did not affect his judgment, and so his decision to enter into the contract was one that involved his exercise of free will. It was therefore difficult to show that the threat had affected his decision-making such that it could be thought of as duress. Examining consent. The effect of duress is that it negates the will of the parties, but this is subject to some interpretation. Negating of consent does not have to be total, but can be satisfied if the alleged victim is required to choose between the lesser of two evils. In D&C Builders, 1966, case, the creditor had a choice of either accepting the money and the revision to the agreement, or suing the other party for breach of contract. However, as the victim was in financial difficulty, they did not have the time or resources necessary to pursue a claim in the courts. Therefore, there was duress present, because it required them to choose under the constraints imposed by the threat. In order to find effected consent, therefore, we can look for situations where a party to a deal has no realistic choice. While the common law doctrine of duress is concerned with the procedure by which a contract was agreed, the equitable doctrine of undue influence is focused upon the relationship between the parties. Equity acts upon the conscience, and the equitable doctrine of undue influence operates where the people are in a relationship where one party relies upon the other. The court in Royal Bank of Scotland v. Ettridge, No. 2, 2001, described the doctrine as one of the grounds of relief developed by the courts of equity as a court of conscience. It is something that stops short of duress, as a specific threat made against the other party is not required. We could summarize the doctrine by saying that undue influence arises because of a subtle influence that another person has over the other party when one person occupies a position of power over the other party and can use that position to influence the other party to enter into a contractual agreement. The objective is to ensure that the influence of one person over another is not abused. In the past, courts divided undue influence into two categories: actual undue influence and presumed undue influence. Royal Bank of Scotland v. Ettridge re-explained what was meant by this division. In one instance, undue influence was presumed as a matter of law by reason of the type of relationship between the parties. In the other instance, undue influence would not be presumed by law, but it was open to a party to establish an evidentiary presumption of undue influence. Actual undue influence. In such cases, the claimant must prove that the wrongdoer actually exerted an undue influence upon the complainant to enter into the transaction in question. In these instances, the criteria are: 1. That the party to the transaction, or a person who induced a transaction for his benefit, had the capacity to influence the other party. 2. That he did influence the other party. 3. That the exercise of this influence was undue. 4. That it was because of this influence that the transaction was brought about. In a situation of actual undue influence, it is not necessary to show that the transaction was manifestly disadvantageous to the party subject to the undue influence. See Lloyds Bank v. Bundy, 1975. In CIBC Mortgages v. Pitt, 1993, a husband put pressure on his wife to agree to a £150,000 loan being taken out on the house they jointly owned in order to buy shares. The husband encountered problems with repayment of the loan after the stock market crash in the late 1980s, and the bank attempted to repossess the house in order to recover the amount of the loan. When the bank attempted repossession, the wife argued that she had only agreed to the loan because of the pressure that had been placed upon her by her husband. The undue influence in question came from a campaign of sustained pressure, rather than a particular threat. At trial, the court was satisfied that this course of conduct was such that amounted to actual evidence of undue influence. The campaign of sustained pressure overcame her initial objection to the purchase. Presumed undue influence. Here the claimant need not prove that there was actual undue influence. These situations, according to Lord Nichols in Royal Bank of Scotland v Ettridge, No. 2, 2001, may arise in one of two ways. In the first case, the law makes a genuine presumption in relation to certain, defined types of relationships, such as doctor and patient, solicitor and client, trustee and beneficiary, religious advisor and disciple. Since the Ettridge, No. 2, case, a finding of the existence of one of these relationships places the parties in a protected situation where the presumption of influence cannot be rebutted. Merely the finding that the influence was undue is under consideration. To allow otherwise would call into question the validity of that relationship's presence, as they are said to be relationships that always conform to the same type. The burden of proof in establishing the presumption of influence lies with the party claiming undue influence. In the above situations, once that burden has been discharged, this presumption of influence is fixed and cannot be discharged. This is the consequence of the way in which the specially protected classes are now regarded in the wake of the Ettridge, No. 2, judgment. However, there are several categories that do not give rise to this automatic presumption but may fall into another category instead. This is because these are situations where it is possible to prove that there is a close relationship of trust and confidence, but it should not be automatically assumed from the existence of the relationship. These are husband and wife, banker and customer, employer and employee. By extension, one would also logically consider all marriages since the Marriage, Same-Sex Couples, Act 2013, as well as civil partners, cohabitees and anyone else in intimate personal relationships. See Future Loans Limited v. Julianne Porter and Daniel Luigi Gianquito, 2015. In these second-type cases, there is a shift in the evidential burden of proof from the complainant to the other party, to show that the transaction was made without improper influence. For this situation to arise, two elements are required. Firstly, that the complainant reposed trust and confidence in the other party, or the other party acquired ascendancy over the complainant. Secondly, that the transaction is not readily explicable other than as resulting from undue influence. In other words, the complainant may prove the de facto existence of a relationship under which the complainant generally reposed trust and confidence in the wrongdoer. The existence of such relationship raises the presumption of undue influence. See Barclays Bank v. O'Brien, 1994. The burden of proof then shifts to the alleged wrongdoer to disprove that they did not exercise undue influence, which is done by establishing that the complainant acted independently and understood his or her actions. In Annulment Funding County Limited v. Cowie, 2010, the Court of Appeal found that actual undue influence and evidence-based presumed undue influence could be considered as alternatives by the court. This case concerned a man who was declared bankrupt, but who had a beneficial interest in a house, jointly with his partner, the amount of which more than covered the amount of debt that had led to the bankruptcy. He engaged Annulment Funding, a company that specialized in annulling the bankruptcy of its clients by loaning them the amount required to pay off the creditors in bankruptcy in the form of a bridging loan. This is a short-term loan, used until the now discharged bankrupt client can obtain a mortgage on their property to pay back Annulment Funding Limited. In Mr. Cowie's case, the mortgage broker was unable to find a mortgage, and so Annulment Funding took action to recover the amount of the bridging loan by repossession and sale of the house that Mr. Cowie and his partner jointly owned. Mr. Cowie's partner argued that the agreement she had entered into regarding the bridging loan was subject to Mr. Cowie's undue influence and argued for a presumption to be set up of undue influence that would then need to be rebutted by Annulment Funding in order for them to be able to repossess the house. The court held that there was enough evidence to establish a case of actual influence and found on this basis. It also held that even where a party argues for a finding of presumed influence on the basis of evidence, the court is at liberty to find that actual influence had taken place on the basis of that evidence, and as there had not been enough evidence to demonstrate actual influence, presumed undue influence could be used as an alternative. How to avoid a presumption of undue influence? In the latter cases mentioned, again, the burden is upon the party claiming influence to establish a presumption. However, this is done through evidence of the relationship at hand, to demonstrate that trust and confidence exists. This therefore leads to a presumption that one party has influence over the other. This is where these cases are different from the automatic presumption ones discussed earlier. The burden here is reversed, and it is then up to the other party to rebut this presumption of influence. This can be done most effectively by showing that the other party was not in fact induced and entered into the agreement freely. So if you were accused of unduly influencing someone's decision to enter into a contract with you, the most effective way of rebutting the presumption that you have influence over them, such that they have trust and confidence in you, is to show that they made the decision independently, maybe through showing that they had independent advice. This would therefore demonstrate that the decision made was one that was a fully informed one, based upon independent advice and not solely upon the influence of the other party. You should note that the concept of manifest disadvantage is no longer useful in analysing instances of undue influence. Lord Nichols in Ettridge, No. 2, commented that transactions of a more unusual nature, for example an unusually large gift, would call for further explanation. The actions of an employee towards their employer in putting their house up as collateral security for the overdraft of the company in Credit Lyonnais Netherland NVV Birch, 1997, which would cause a bank manager to raise his eyebrows more than a little, gives some insight into the meaning of something calling for an explanation. This approach of the House of Lords is understood to have discarded the idea of manifest disadvantage, and relied more heavily upon the judgment of Allcard v. Skinner, 1887, where the court proposed the idea that where a gift is so large as not to be reasonably accounted for on the grounds of friendship, relationship, charity or other ordinary motives on which ordinary men act, then it is down to the person receiving that gift to provide an explanation. The intervention of a third party gives rise to difficulties. In practice, most litigation occurs where the relationship of undue influence arises between A and B, whereby B enters into a contract with C for the benefit of A. The most common instance of this scenario is when the relationship of undue influence exists between spouses and one spouse induces the other to enter into a transaction with a bank. The most common way in which the bank can rebut the possibility of undue influence is by notice, meaning to inform the spouse as to the nature of the transaction and advise them to seek legal advice. In Barclays Bank v. O'Brien, 1993, a wife had entered into an agreement for a charge to be placed on the matrimonial home to guarantee the overdraft of the husband's company. The transaction took place at a different branch to the one that the couple usually used, and therefore the O'Brien's bank manager had left instructions for both parties to be fully appraised of the current state of the overdraft and to advise them to speak to their solicitor if they had any concerns prior to entering into the agreement. Unfortunately, the branch did not follow their instructions, and therefore the wife was unaware of the extent of the overdraft. She thought it was at £60,000 when, in reality, it was at £135,000. When the company's overdraft reached £154,000, the bank attempted to repossess the house under the legal charge that had been placed upon it. The wife claimed that she had entered into the agreement because of the undue influence of her husband and attempted to get the transaction set aside. The court discussed policy considerations, with the growing number of cases involving wives, but rejected the idea of some form of special protection for wives or others in similar relationships, mainly because this might give a shortcut back to an automatic presumption of undue influence for such parties. The court found that the transaction was of such a nature that in order to avoid being fixed with constructive notice, the bank would have to demonstrate that certain steps had been taken by them. Constructive, or legal, notice is a presumption that a party has notice when it can discover certain facts by due diligence or inquiry into the public records. A party found to have constructive notice cannot deny knowledge of a fact because that party did not have actual knowledge, since there is a duty to conduct due investigation. Guiding the bank to appropriately handling agreements where there is potentially dangerous power or knowledge mismatch between the parties relies upon the bank being put on inquiry in certain circumstances. Those circumstances were a. The transaction is on its face not to the financial advantage of the wife, and b. There is a substantial risk in transactions of that kind that, in procuring the wife to act as surety, the husband has committed a legal or equitable wrong that entitles the wife to set aside the transaction. If it was subsequently shown that there had been undue influence, the bank would have constructive knowledge of the undue influence unless they could show that they had taken reasonable steps to establish that the wife had entered into the transaction freely and knowing the facts. The court held that, as this had not happened in O'Brien for instance, the bank had constructive notice of the undue influence and could not repossess the family home. Lord Nichols' judgment in the Ettridge, No. 2, case provides guidance on the matter of avoiding constructive notice. The bank needs to make sure that a solicitor is named by the wife, and that this solicitor is instructed to advise separately to the husband. This can be the same solicitor that her husband uses, but the wife must be given the opportunity to nominate a separate solicitor. The solicitor must advise the wife on the nature of documents and practical implications of signing them. They must also explain that the wife will be legally bound by documents once signed. As the banker in the best position to explain the financial situation, they must either do so, or pass on all the relevant financial data to allow the solicitor to properly explain the situation. The solicitor's role is then to advise and confirm in writing that this has taken place. Without the written confirmation from the solicitor, the bank should not proceed with the transaction. Even if it later transpires that the wife was subjected to undue influence, if these steps are followed, then the wife will not be able to use the undue influence to argue that the transaction with the bank is unenforceable. As with duress, the main remedy for undue influence is to make the contract voidable at the victim's discretion. Therefore, the ability to rescind the contract is available. As discussed earlier for duress, if no rescission has been applied for, this can be deemed to be constructive affirmation of the contract, and remedies will no longer be available. See North Ocean Shipping v. Hyundai Construction, the Atlantic Baron, 1979, case. In Allcard v. Skinner, 1887, the plaintiff had joined a religious group called Sisters for the Poor, while under the influence of her spiritual advisor. During her time as part of this group, she had given approximately £7,000 to the religious leader. She left the group and, 6 years after having left, she attempted to reclaim money that she had paid. The court found that the long delay between leaving the order and claiming the money could be construed as being a constructive affirmation of the contract, and she was not entitled to recover the money. It is useful to remember that undue influence cases are not only about disputes arising out of intimate relationships. They can be very much commercial in nature, as evidenced in the Libyan Investment Authority v. Goldman Sachs International, 2016, where Rose J. dismissed a claim by the Libyan Investment Authority in which it asserted that Goldman Sachs International had exerted undue influence over its employees, which resulted in it making improper investments and which in turn caused losses of $1.2 billion United States dollars. Goldman denied these claims and contended that 1. The relationship did not go beyond an ordinary relationship of banks selling investment products to a wealthy client, and 2. The LIA, being a sovereign wealth fund, was a more sophisticated investor than it claimed to be. Duress and undue influence can have a significant effect upon a contractual agreement because they render a contract voidable at the discretion of the victim if proved. Duress is available at common law, whereas undue influence is an equitable doctrine, to be applied at the discretion of the court where appropriate. These two areas are considered an important part of the law of contract because that contractual agreements are supposed to be made through the free will of the parties. Duress and undue influence are considered vitiating factors, because arguably they interfere with the ability of a person to freely and willingly enter into a contract. When considering the effect of a finding of duress or undue influence, it is important to consider the impact upon parties to the contract, as well as third parties involved. The law has attempted to engage in a balancing act between the rights of a party whose will has been vitiated, and a third party who may also be innocent in the situation, yet is burdened with a duty to discharge, as is the case with banks. This is a dynamic area of the law with new cases frequently coming before the courts. We move on to a different set of problems that parties can face with contractual performance. The doctrine of frustration provides that if, after a contract is entered into, events occur without the fault of either party which make it impossible physically or commercially, if it loses its commercial purpose, to perform the contract, then it is automatically terminated, so as to relieve both parties of their future obligations under it. Whether or not a contract will be regarded as frustrated depends upon the obligations created by the contract and the circumstances that occur. It is key to remember that frustration is exceptional and provides one of a variety of ways by which contractual obligations end. Where a contract is discharged by frustration, this occurs automatically by operation of law. The courts decide when a contract has been frustrated, and, if they decide that it has, then all future obligations cease. The consequences of this are dealt with by both common law rules and statute. The Law Reform, Frustrated Contracts, Act 1943. Key cases explaining the requirements for frustration include Taylor v. Caldwell, 1863, and Davis Contractors Limited v. Fareham Urban District Council, 1956. We will start our overview of this area of the law by looking at some of these key cases. In Taylor v. Caldwell, 1863, the courts regarded most contractual obligations as absolute. As the promisor promised to perform, come what may, he could not rely upon supervening events, other than breach of contract by the other party, as an excuse for non-performance. In Lauritsen v. Wymuller B.V., known as the Superservant II, remember that shipping cases are normally referred to using the name of the vessel. Bingham LJ explained that certain propositions, established by the highest authority, are not open to question. 1. The doctrine of frustration was evolved to mitigate the rigor of the common law's insistence on literal performance of absolute promises. The object of the doctrine was to give effect to the demands of justice, to achieve a just and reasonable result, to do what is reasonable and fair, as an expedient to escape from injustice where such would result from enforcement of a contract in its literal terms after a significant change in circumstances. 2. Since the effect of frustration is to kill the contract and discharge the parties from further liability under it, the doctrine is not to be lightly invoked, must be kept within very narrow limits and ought not to be extended. 3. Frustration brings the contract to an end forthwith, without more and automatically. 4. The essence of frustration is that it should not be due to the act or election of the party seeking to rely on it. 5. A frustrating event must take place without blame or fault on the side of the party seeking to rely on it. An example of this harshness of the rules of contract before the evolution of the doctrine of frustration, that Bingham LJ mentioned is Paradine v. Jane, 1647. In that case, a farm tenant was excluded from his farm for 2 years by enemies of the king, and claimed that he was not liable for the rent for the period he was dispossessed. It was held that he was liable regardless, as he had assumed the obligation. In situations where there is a change in circumstances, not attributable to the fault of either party, such that performance of the contract would become something radically different from what the parties originally intended, justice requires that the courts should treat the contract as having come to an end. See National Carriers Limited versus Panalpina, Northern, Limited, 1981. It is quite possible for the parties themselves to make provision in the contract for what is to happen should the performance of the agreement become impossible, or radically different, as a result of some subsequent event for which neither of them is to blame. This is common in commercial contracts, which frequently use what are known as force majeure clauses. Where there is a clause of this type which covers the situation which has occurred, then the courts will give effect to it. The issue will not longer be one of frustration, as contractual provision will take precedence. We only talk of frustration when the event is not in fact addressed by the agreement between the parties. Be careful with this distinction, as in most jurisdictions material on force majeure and frustration will be distinct. We now move to discuss more closely the nature of possible frustrating events. Courts have consistently indicated that a contract will be frustrated only where there is a complete change between what was undertaken in the contract and the circumstances in which it is called upon to be performed. See for example CTI Group Inc. vs. Transclear SA, 2008. The following types of frustrating events have been noted in the case law: destruction of the subject matter, personal incapacity, non-occurrence of an event, or failure of the commercial purpose, effects of war and other government action. We now look at each of them in turn. Destruction of subject matter. The most obvious example is where the main subject matter of the contract has been destroyed, as in Taylor v. Caldwell, 1863. In this case, defendants Caldwell and Bishop owned Surrey Gardens and Music Hall, and agreed to rent it out to the plaintiffs, Taylor and Lewis, at the rate of £100 per day. The plaintiffs had planned to use the music hall for 4 concerts for 4 different dates during the summer of 1861, and had intended to provide a variety of extravagant entertainments. According to the contract the parties had signed, the defendants were to provide most of the performers. The plaintiffs were to receive the gate receipts and advertise for these events. Then, tragically, on June 11, 1861, a week before the concert was to be given, the music hall burned to the ground. The plaintiffs sued the music hall owners for breach of contract for failing to rent the music hall. There was no clause within the contract itself which allocated the risk to the underlying facilities, except for the phrase, "God's will permitting," at the end of the contract. Judge Blackburn reasoned that the rule of absolute liability set forth in Paradine v. Jane only applied to positive, definite contracts, not to those in which there was an express or implied condition underlying the contract. Blackburn further reasoned that the continued existence of the music hall in Surrey Gardens was an implied condition essential for the fulfillment of the contract. The destruction of the music hall was the fault of neither party, and rendered the performance of the contract by either party impossible. Blackburn cited to the Civil Code of France and the Roman law for the proposition that when the existence of a particular thing is essential to a contract, and the thing is destroyed by no fault of the party selling it, the party are freed from obligation to deliver the thing. He further analogized to a situation in which a contract requiring personal performance is made, and the party to perform dies. The party's executors are not held liable under the common law of England. Blackburn thus held that both parties were excused from their obligations under their contract. Personal incapacity. Another clear case of frustration will be where both parties have agreed that the contract is to be carried out by a particular individual, and that individual dies or is too ill to perform. See Condor v. Baron Knights, 1966. In Hart v. Marshall & Sons, 1978, employee began employment as a night service fitter in 1968. In April 1974 he became ill, and during his absence from work he sent regular medical certificates to his employers. On January 27, 1976, when he told the employers that he had recovered, they informed him that there was no longer any work for him and gave him his P45 form and holiday pay. On the employee's complaint of unfair dismissal, there was no evidence before the Industrial Tribunal of the terms of the contract of employment, and the tribunal heard the complaint on the basis that there were no contractual terms regulating the position of a sick employee and that he was not entitled to be paid during his absence. The tribunal found that the employee was a key worker and that the employers were justified in engaging a replacement fitter after the employee had been absent for 4 months, that the employers had not dismissed the employee but that his contract had been terminated by frustration, and they dismissed the complaint. On the employee's appeal, the court held that the Industrial Tribunal were correct in holding that the contract was frustrated and the employee had not been dismissed. Non-occurrence of an event. A number of cases concerned with the cancelled coronation of King Edward VII in 1903 illustrate this category. See Krell v. Henry, 1903, and Herne Bay Steamboat County v. Hutton, 1904. The core of these cases is the idea that if the commercial purpose of the contract has failed completely, then the contract should be considered frustrated. In Krell v. Henry, 1903, the defendant agreed to hire from the plaintiff a flat in Pall Mall for June 26 and 27, on which days it had been announced that the coronation processions would take place and pass along Pall Mall. The coronation of Edward VII and Alexandra of Denmark as King and Queen took place at Westminster Abbey, London, on the 9th of August 1902. Originally scheduled for the 26th of June of that year, the ceremony had been postponed at very short notice, because the king had been taken ill and required immediate surgery. The contract contained no express reference to the coronation processions, or to any other purpose for which the flat was taken. A deposit was paid when the contract was entered into. As the processions did not take place on the days originally fixed, the defendant declined to pay the balance of the agreed rent. The court held from necessary inferences drawn from surrounding circumstances, recognized by both contracting parties, that the taking place of the processions on the days originally fixed along the proclaimed route was regarded by both contracting parties as the foundation of the contract, that the words imposing on the defendant the obligation to accept and pay for the use of the flat for the days named, though general and unconditional, were not used with reference to the possibility of the particular contingency which afterwards happened, and consequently that the plaintiff was not entitled to recover the balance of the rent fixed by the contract. In other words, therefore, the postponement of the coronation meant that the contract had been frustrated and the parties were released from the obligation of further performance. Not all cases arising from these facts, however, led to the same conclusion. Herne Bay Steamboat County v. Hutton, 1903, arose from the same set of events. In consequence of the public announcement of an intended Royal Naval Review at Spithead on June 28, 1902, an agreement in writing was entered into between the plaintiffs and the defendant that the plaintiff's steamship Cynthia should be at the disposal of the defendant on June 28 to take passengers from Herne Bay, for the purpose of viewing the Naval Review and for a day's cruise round the fleet. Also on June 29 for similar purposes. Price payable before ship leaves Herne Bay. On the signing of the agreement, the defendant paid a deposit. On June 25 the review was officially cancelled, whereupon the plaintiffs wired to the defendant for instructions, stating that the ship was ready to start, and also requesting payment of the balance. Receiving no reply, the plaintiffs, on June 28 and 29, used the ship for their own purposes, thereby making a profit. On June 29 the defendant repudiated the contract. During the 2 days in question the fleet remained anchored at Spithead. In an action by the plaintiffs to recover the balance less the profits made by their use of the ship during the 2 days, it was held that the plaintiffs were entitled to recover, because the venture was the defendant's, the risk being his alone, and the happening of the Naval Review was not the sole basis of the contract, so that there had been no total failure of consideration, nor a total destruction of the subject matter of the contract effects of war. In time of war, a government may make trading with companies based in enemy territory illegal. Contracts with such companies which were made prior to this action will be frustrated. The key case here is Fibrosa Spolker Aktiena versus Fairbairn Lawson Coombe Barber Limited, 1943. Note, however, that frustration need not result from direct government action, as in Finelvertag versus Vinava Shipping County Limited, 1983. In Fibrosa Spolker Aktiena Appellants versus Fairbairn Lawson Coombe Barber, 1943, an English company agreed to sell and the appellants, a Polish company, agreed to purchase machinery of which 1/3 was to be paid with the order. Delivery was to be 3 to 4 months from settlement of final details and the goods were to be packed and delivered to Poland. The sale was made subject to certain conditions, including a provision that stated, should dispatch be hindered or delayed by any cause whatsoever beyond our reasonable control, including war, a reasonable extension of time shall be granted. On September 1, 1939, war broke out between Germany and Poland, and on September 3, Great Britain declared war on Germany. On and after September 23, the delivery port was occupied by the Germans. It was held that, contractual provision being limited in its ambit to a delay in respect of which a reasonable extension of time might be granted, did not prevent frustration of the contract by reason of the war on the ground that it made express provision for that contingency, since this war involved prolonged and indefinite interruption of prompt contractual performance, and that, there having been a total failure of consideration, the appellants could recover partial payments made by the respondents. Other government action not related to war can also frustrate a contract. See Gameco SA versus ICM, Fair Warning Agency, 1995. Gameco were promoters who entered into an agreement to promote a concert in Madrid with the defendants, the corporate persona of the band, Guns N' Roses. A few days before the concert, engineers reported the venue was structurally unsound and the authorities banned its further use pending further investigations. Gameco's license to use the venue was revoked. Gameco had paid the defendants large sums on account and they sought recovery. It was held that the contract was frustrated because it had become incapable of performance because the authority cancelled the permit. A term was implied into the contract that Gameco would take all reasonable steps to attain the permit, but they were not required to ensure it remained in force. They could, therefore, recover the advance payments under S.1.2 of the 1943 Act. Other frustrating events. Other types of event which have led to contracts being frustrated include industrial action, as in the NEMA, 1981, and the accidental running aground of a ship. See Jackson v. Union Marine Insurance County Limited, 1874. Inordinate delay could form a basis for frustration as well, as in Bankline v. Capel, 1919. There are two principal limitations on the doctrine of frustration. The first is where the frustrating event has been foreseen and provided for in the contract. The second is where the alleged frustrating event has been self-induced by one of the parties. In the commercial area, force majeure and similar clauses may well replace the common law and statutory rules on frustration. The courts have tended to narrowly interpret such clauses. See Jackson v. Union Marine Insurance County Limited, 1874. First, we deal with the issue of foreseeability. The case of Ocean Tramp Tankers Corp. versus V.O. Sofract, the Eugenia, 1964, illustrates these key limitations well. First of all, we can consider how foreseeable does the event need to be to prevent frustration. A. If there is contractual provision for this event, no frustration. B. If the event not covered, how different is it from the situations provided? Lord Denning argued that a contract would be frustrated if it were unjust to hold the parties to the bargain. We can inquire therefore if the contract has become something radically different. The Eugenia was let to the charterers for a trip out to India via Black Sea, from the time the vessel was delivered to the charterers at Genoa. The charter party contained a customary war clause, which provided the vessel, unless the consent of the owners be first obtained, not to be ordered nor continue to any place or on any voyage nor be used on any service which will bring her within a zone which is dangerous as the result of any actual or threatened act of war, war hostilities, warlike operations. Quote. When the charter party was negotiated, the agents of both parties realized that the Suez Canal might be closed, but no express terms were inserted in the charter to meet that eventuality. The vessel was delivered at Genoa. She sailed from Odessa, the customary route at this time to India being still by the Suez Canal. She arrived at Port Said when Egyptian anti-aircraft guns were in action. Port Said and the Suez Canal were then zones which were dangerous within the clause. The vessel entered the canal and proceeded south. The canal was blocked by the Egyptian government, and the vessel was trapped. The charterers claimed that the charter party had been frustrated by the blocking of the canal. The owners denied frustration. They treated the charterers' conduct as repudiation and claimed damages. The court held that this was a time charter, the essence of which was that the ship owners placed the vessel at the disposal of the charterers. The vessel was under the charterers' orders when she approached the Suez Canal, and the charterers were in breach of the war clause when they ordered her to enter the canal. The blocking of the Suez Canal did not bring about so fundamentally different a situation as to frustrate the venture. It becomes therefore necessary to determine whether a party assumed the risk of the occurrence of the event that lies at the root of the inability to perform the contract. Further, if performance is rendered merely more expensive, inconvenient, difficult, the contract will not be frustrated as a result. In Davis Contractors v. Fareham Urban the 600th, 1956, Lord Reed said that, "It appears to me that frustration depends, at least in most cases, not on adding any implied term but on the true construction of the terms which are in the contract, read in the light of the nature of the contract and of the relevant surrounding circumstances when the contract was made." On this view, there is no need to consider what the parties thought, or how they or reasonable men in their shoes would have dealt with the new situation if they had foreseen it. The question is whether the contract which they did make is, on its true construction, wide enough to apply to the new situation. If it is not, then it is at an end. According to Lord Radcliffe, frustration occurs whenever the law recognizes that, without default of either party, a contractual obligation has become incapable of being performed because the circumstances in which performance is called for would render it a thing radically different from that which was undertaken by the contract. It was not this that I promised to do. The case involved plaintiffs agreeing to build 78 houses for the defendants. The work was to be completed within 8 months. Before the contract was signed, the plaintiffs had written to the defendants, "Our tender is subject to adequate supplies of material and labor being available as and when required to carry out the work within the time specified. Owing to bad weather, but more particularly to an unforeseen shortage of available labor, due to an unexpected lag in the demobilization of troops after the war, the work took 22 months to complete." The contractors received the contract price, but they claimed that by reason of the delay they were entitled to treat the contract as void and to be paid on a quantum meruit, meaning payment for work done outside a contract. The House of Lords held that in a contract of this kind the contractor undertook to do the work for a definite sum, and he took the risk of the cost being greater or less than he expected. If delay occurred through no one's fault, that might be in the contemplation of the contract and there might be provision for extra time being given. To that extent the other party took the risk of delay, but he did not take the risk of the cost being increased by such delay. It might be that delay could be of a character so different from anything contemplated that the contract would be at an end, but in this case the most that could be said was that the delay was greater in degree than was to be expected. It was not caused by any new and unforeseeable factor or event. The job proved to be more onerous, but it never became a job of a different kind from that contemplated in the contract. We now move on the issue of self-inducement of the frustrating event. Another important element in the doctrine of frustration is that the alleged frustrating event must not be attributable to the fault of either party. If it is, then the likelihood is that the party at fault will be in breach of contract and the doctrine of frustration will have no application. The courts have interpreted the concept of fault widely in this context. In fact, it may be more accurate to say that wherever the alleged frustrating event is attributable to the actions of one of the parties, whether these involved fault or not, then the doctrine of frustration will not apply. See Maritime National Fish v. Ocean Trawlers, 1935. In Lauritsen as versus Weimüller B.V., 1990, the defendants, Weimüller, agreed to carry the plaintiffs, Lauritsen's, drilling rig, Dan King, from the Hitachi shipyard at Ayake, Japan to a delivery location off Rotterdam. The drilling rig was to be delivered between June 20, 1981 and August 20, 1981 and was to be carried by using what the contract described as the transportation unit. The unit was defined as meaning Superservant 1 or Superservant 2. The defendants were given the right to cancel the performance under the contract in the event of force majeure or any other circumstances whatsoever which reasonably prevented the performance of the contract. The defendants also had the right to substitute the transportation unit by other means of transport, and there was a duty of care clause in which the defendants agreed to do everything that a good carrier might reasonably be expected to do in order to reach the port of discharge in time and safety. On January 29, 1981, Super Servant 2 sank. The defendants had intended to use Super Servant 2 for this contract. They had entered into other contracts with other persons which they could only perform using Super Servant 1. On or about February 16, 1981, the defendants informed the plaintiffs that they would not carry out the transportation of the drilling rig with either Super Servant 1 or Super Servant 2. The plaintiffs claimed the losses they had suffered, and the defendants counterclaimed in respect of the increased expenses they had incurred. The court held that under the contract the defendants could have satisfied their obligation by using Super Servant 1 to carry Dan King after Super Servant 2 had sunk, but they elected not to do so. The doctrine of frustration only availed a party who contracted to perform a contract of carriage with a vessel which through no fault of his own no longer existed, but that was not this case. The Dan King contract did provide an alternative. The sinking of Super Servant 2 did not automatically and without more ado bring the contract to an end by reason of frustration. Even after the sinking, the defendants could have used Super Servant 1. The real question was whether the frustrating event relied on was truly an outside event or extraneous change of situation, or whether it was an event which the party seeking to rely on it had the means and opportunity to prevent but nevertheless caused or permitted to come about.
Ever tried to cancel a reservation only to be told, "Sorry, this is not refundable"? Do they have the right to keep your money? The doctrine of frustration gives us the answer. This refers to a situation when a contract becomes legally impossible to perform. And to explore it, we're going back in time and to Washington, D.C. In January 2025, the outdoor inauguration event for President Donald Trump was partially canceled due to extreme weather. Among the disappointed were thousands of out-of-towners, including one couple who had booked a pricey hotel in the city.
We were only staying because of the inauguration parade. We planned the whole trip around it. But with the outdoor ceremony canceled, the event we came for didn't happen. We asked the hotel for a refund, and they said no. They said the room was still available, but we didn't get what we bargained for.
This reminds me of Krell versus Henry from 1903. A fellow had rented a room in Pall Mall solely to view the king's coronation procession. The coronation was cancelled due to illness, and the court said the very purpose of the contract had disappeared. The contract was frustrated.
Exactly. We didn't want a room. We wanted to attend the inauguration. If the parade is off, the reason for the room is gone.
But beware Herne Bay Steamboat versus Hutton. That same summer, a man hired a boat to watch a naval review and cruise the fleet. The naval review was cancelled, but the cruise could still happen. The court said, no frustration, some purpose survived.
But our event was cancelled.
But the room was still there.
So who's right? Under English law, frustration only applies when the event is so central to the contract that its cancellation makes performance radically different. If the room was just a room, no refund. If the room was for the view of the cancelled event, maybe. The doctrine of frustration isn't about inconvenience, it's about impossibility, or a fundamental change in the nature of the agreement. And as always in law, the devil is in the detail.
One common law rule which operates even where the act is also applicable is that a frustrating event terminates the contract automatically, without any need for action by either party. It follows that any attempt to affirm the contract following frustration will be ineffective. See here G. Mulji v. Chongyong Steamship County Limited, 1926. As to the distribution of losses following frustration, the common law started from the position that all future obligations were discharged, post the frustrating event, but that obligations incurred prior to the event survived. Where the loss fell would therefore depend entirely on what the contract said about when payment was to be made, or when work was to be done. See Chandler v. Webster, 1904, and Fibrosa Spolker Aktiena v. Fairbairn Lawson Coombe Barber Limited, 1943. The inflexibility of the common law rules, even following the slight modification provided by the Fibrosa case, led to demand for reform. This occurred in the shape of the Law Reform, Frustrated Contracts, Act 1943. The two main provisions in the 1943 Act are S.1.2, which deals with money paid or payable prior to the frustrating event, and S.1.3, which deals with benefits conferred prior to that event. Section 1(2) provides that where money was paid or payable prior to the frustrating event, it should be returned, if paid, or should cease to be payable, if not paid but owing. Unlike the common law, this is not dependent on there being a total failure of consideration. A total failure of consideration will entitle a claimant to seek a restitutionary remedy. Wynkoop v. Hughes, 1871, is authority for the proposition that the claimant may seek a restitutionary remedy by saying that the basis upon which he conferred a benefit has failed entirely, in this case because of the defendant's breach of contract. If any part of the contract is performed, or if the claimant has received any part of the consideration, the restitutionary claim is barred. See Tinsley v. Milligan, 1993, and Lipkin-Gorman v. Carpnail, 1992. Section 1(2) of the 1943 Act provides that if expenses have been incurred towards the performance of the contract, some of the money paid or payable may be retained or recovered, to the extent that a court considers it just in all the circumstances. Section 1(3) deals with the situation where a party has received a benefit other than money prior to the point at which the contract was frustrated. In that situation, the section allows that the party to recover from the other party such sum as the court considers just, having regard to all the circumstances of the case. In BP Exploration Co., Libya, Limited v. Hunt, No. 2, 1979, BP entered an agreement with Hunt, under which BP would explore and develop his oil concession in Libya at their own expense. This expenditure would be recoverable from Hunt's share of the profits when the field produced oil. After oil production began, the parties would share both production and development costs. Oil came on stream in 1967, but in 1971 the Libyan government seized BP's interest. BP had not received all its initial expenditure from Hunt's share, and arguing that the contract had been frustrated by government action, claimed a just sum under S1 Law Reform, Frustrated Contracts, Act 1943. The court held that the contract had been frustrated in 1971. At the date of frustration, Hunt had received a benefit under the contract because of BP's contractual performance, and this sum was to be taken into account. This completes our presentation of the main features and operations of the English law doctrine of frustration. We now move on to a summary of the main aspects of the doctrine of misrepresentation. We will see what an actionable misrepresentation is and will discuss potential remedies such as rescission of the contract and damages. Finally, we will present how any attempts to exempt liability for a misrepresentation can operate under the Unfair Contract Terms Act 1977 and the relevant provisions in the Consumer Rights Act of 2015. When negotiating a contract, the prospective parties may say many things which are designed to encourage the other party to enter into the contract. Sometimes these statements become terms of the eventual contract. If they do not, a remedy may nevertheless be available to a party who has been induced to enter into a contract in reliance on a falsehood. After the Misrepresentation Act 1967, more extensive remedies in damages available for misrepresentation were introduced into English law, under S.2 of the Act, and S.1a provides that a contract may be rescinded for misrepresentation, even if the misrepresentation is also a term of the contract. For a misrepresentation to be actionable, it must be a false statement of existing fact or law. A statement of opinion is not generally a misrepresentation. See Bissett v. Wilkinson, 1927. Two exceptions exist. The first is where the person expressing the opinion is aware of facts which indicate that the opinion cannot be sustained. See Smith v. Land House Corporation, 1884. The second exception, which can lead to a statement of opinion being treated as a false statement of fact, is where there is evidence that the person making the statement does not believe it at the time that it is made. Proof that the maker of the statement was aware of contradictory facts may prove that they did not believe the statement was true. See Edgington v. Fitzmaurice, 1885. Traditionally, statements of law were not regarded as being statements which, if false, will give rise to remedies for misrepresentation. It seems, however, that now that the House of Lords has recognized the possibility of restitutionary remedies for mistake of law, in Kleinwort Benson Limited v. Lincoln City Council, 1999, the same approach may well apply in the area of misrepresentation. If the statement of law is not believed by the person making it, then the principle in Edgington v. Fitzmaurice will apply, so that the statement will be treated as a misrepresentation of the person's state of mind. Let us explore the above possible misrepresentations through a list of examples. If Yorgos buys John's bicycle after being told that it is a mountain bike and it turns out to be a street bike, would he have a claim for misrepresentation? The answer would be yes, as a false statement of fact was made that induced John to enter into the contract. If on the other hand Yorgos told John that he thinks this is a great bike, this is unlikely to be sufficient basis for a finding of misrepresentation, as it sounds like a statement of opinion, and it is not specific enough to be manifestation of expertise or an outright lie. If Yorgos knew that the bike is faulty, but did not share that information, then there is no statement on which to base a misrepresentation action. Similarly, if Yorgos promised to include a lock chain with the bike, but then fails to provide it, then we should be talking about a breach of contract, promise of future action, rather than a false statement. We will now move on to see the requirements for actionable misrepresentation in some more detail. In order for a misrepresentation to be actionable, it must induce the person to whom it is addressed to make a contract. This simply means that the statement must be one of the factors which led the person to enter into the contract. It does not have to be the sole or main reason. See Edgington v. Fitzmaurice, 1885. The representation must play a real and substantial part of the claimant's decision to enter into the contract. See Redgrave v. Hurd, 1881. If the misrepresentation would have induced a reasonable person to contract, the court will presume that it did so induce the representee to contract in this instance. Is it possible to induce misrepresentation by silence? A misrepresentation generally requires an oral or written statement. There are, however, some exceptions to this. First, it is clear that in certain situations conduct can be treated as implicitly making a statement. If the implicit statement turns out to be untrue, then it may be a misrepresentation. See Spice Girls Limited v. Aprilia World Service BV, 2000. The case involved the iconic 90s girl group. The group signed a sponsorship agreement, but subsequently resisted payment, saying that one of the five, Jerry, also known as Ginger Spice, had given notice to leave the group, substantially changing what had been promised. The girls acknowledged that Jerry had said she would leave, but insisted that no real intention to leave had existed. The court accepted that a person who is about to enter into an agreement is under no duty to disclose material facts which she knows but which the other party does not know. Here, however, the group knew that the other party was relying upon a representation that was false and were as consequence liable in damages. Secondly, where a statement, which was true when made, becomes false as a result of a change of circumstances, keeping silent may be treated as a misrepresentation. See with V. O'Flanagan, 1936. Additionally, there are some contracts which are treated as being of the utmost good faith. This means that parties are obliged to disclose relevant information, even if it is not asked for. See Lambert v. Cooperative Insurance Society, 1975. There are 4 different categories of misrepresentation, which relate principally to the state of mind of the person making the statement. Fraudulent. The maker of the statement knows or believes that the statement is untrue, or makes it not caring whether it is true or false. Negligent at common law. The maker of the statement and the person relying on it are in a special relationship, giving rise to a duty of care under the principles of Hedley Byrne v. Heller, 1964, and the maker of the statement acts in breach of this duty. Statutory misrepresentation. The maker of the statement has no reasonable grounds for believing it to be true. S.2, 1. Misrepresentation Act 1967. See also Foster v. Action Aviation Limited, 2013. Innocent. The maker of the statement genuinely believes it is true, and does not act negligently, at common law or under statute, as above, in making it. The distinction between these categories is vital in determining the remedies which may be available to the person relying on the statement. We now move to consider what remedies are available for misrepresentation depending to its type and circumstances. The remedies available for misrepresentation will depend on whether it was made innocently, negligently, or fraudulently. There are potential remedies available under the common law, both in contract and tort, and under statute. The Misrepresentation Act 1967. The main categories of remedy are first, rescission of the contract, and secondly, damages for losses resulting from the misrepresentation. Rescission is the principal common law remedy for a misrepresentation which induced a contract. This was, and is still, available whether the representation was innocent, negligent, or fraudulent. Rescission, in this context, means that the contract is set aside, and the parties put into the position they would have been in had the contract never been made. Any goods or money which have been exchanged must be returned. The remedy of rescission must be sought by the claimant. It does not occur automatically. It is important to remember that misrepresentation renders a contract voidable, rather than void. There are some situations where the right to rescind will be lost. These are where a party to the contract, aware of the other party's misrepresentation, continues with the contract, and thus affirms it. See Long v. Lloyd, 1958. Where there is a significant lapse of time between the making of the contract and the discovery of the misrepresentation. See Leaf v. International Galleries, 1950. Where restitution is impossible, since the idea of rescission is to restore the parties to the position they would have been in had the contract not been made, if property which has been transferred has been consumed or inextricably mixed with other property, rescission will not be permitted. See Clark v. Dixon, 1858. Where rescission would affect the rights of a third party. The most obvious example is where goods have been sold to the misrepresenter, who has then sold them on to an innocent third party before the contract has been avoided. The common law was late in recognizing a right to damages for non-fraudulent misrepresentations. An innocent misrepresentation provided only an indemnity for necessary expenditures incurred as a part of the contract rescinded by way of monetary compensation. See Whittington v. Seal-Hayne, 1900. Where a misrepresentation is fraudulent, damages may be recoverable under the tortious action for deceit. This requires the claimant to prove that the statement was made knowing that it was untrue, without any genuine belief in its truth, or with a reckless disregard for whether it was true or not. See Derry v. Peake, 1889. The law of tort, in Hedley Byrne v. Heller, 1964, eventually recognized that a negligent misstatement which caused economic loss could be actionable. The action that has developed from this provides another potential remedy for a person who has entered into a contract as a result of a negligent misstatement from the other party. The most important innovation in the Misrepresentation Act 1967 was the introduction of the action for what is generally referred to as negligent misrepresentation, in S.2.1. In fact, the Act does not use this terminology, but provides that a statement which would form the basis of an action in deceit, if made fraudulently, will also give rise to liability unless the person making it is able to prove that he had reasonable grounds to believe and did believe up to the time that the contract was made that the facts represented were true. On the burden of proof, all that the claimant has to do is to prove that a misrepresentation was made and that it induced the contract. The defendant will then be liable for damages under S.2.1, unless he or she can prove that there were reasonable grounds for his or her belief that the statement was true. See Howard Marine and Dredging County v. Ogden and Sons, 1978. As regards the measure of damages, the most important authority is Royscott Trust Limited v. Rogerson, 1991. Here it was held by the Court of Appeal that damages under S.2.1 should be calculated in the same way as if the statement had been made fraudulently. Section 2(2) of the Misrepresentation Act provides a discretion for a court to award damages in lieu of rescission, where it is judged equitable to do so, taking account of the effect of rescission on both parties. The exclusion or limitation of liability for misrepresentation is dealt with by S.3 of the Misrepresentation Act 1967, as amended by S.8 of the Unfair Contract Terms Act 1977. This requires that any clause which attempts to limit liability for misrepresentation must satisfy the requirement of reasonableness set out in S.11 of the Unfair Contract Terms Act, Chapter 6. See Avrora Fine Arts Investment Limited v. Christie, Manson & Woods Limited, 2012. Broad attempts to exclude liability have been found to be unreasonable, even if the clauses are drawn from widely used standard conditions. Sometimes the attempt to exclude liability is put into the form of an assertion, for example, that no statements are made other than those contained in the contract itself. Such entire agreement clauses have been considered in a number of cases. Although there is an early authority, on the pre-UCTA version of S.3, which held that such a clause could be effective to restrict liability for statements made by an agent of the party concerned, Overbrick Estates v. Glencombe Properties, 1974, subsequent cases have generally taken the line that an entire agreement clause, or clauses, which attempt to deny that there is any reliance on pre-contractual statements, do fall within the scope of S.3 as far as liability for misrepresentation is concerned. They would therefore not be successful in protecting a party from a misrepresentation claim. Under the Consumer Rights Act 2015, a new concept of a consumer notice has been introduced. See Part 2 of the Act on Unfair Terms. This means that anything which sets out the rights or obligations of the trader and consumer or restricts the trader's liability will be subject to the same test of fairness as if they were set out in a trader's terms and conditions. This will apply to marketing communications, brochures, and signs at premises, all of which will be treated in the same way as if they were contract terms. Anything said or written to a consumer about a service or trader, whether by or on behalf of the trader, will be treated as a term of the contract if the consumer takes it into account when deciding whether to enter into the contract, and when making any decision about the services after the contract is entered into. This makes it a great deal easier for consumers to bring claims which would previously have had to be pursued under the law of misrepresentation. This presentation offered a summary of the main aspects of the doctrine of misrepresentation. We presented the main elements of misrepresentation, explained what an actionable misrepresentation is, which categories it comes in, and then moved on to consider remedies. We presented rescission and damages, and concluded with a reflection on options for limiting liability for misrepresentation. We conclude our list of contractual problems with the doctrine of mistake. Mistake is a difficult area of contract law. A major reason for the difficulty is that the common law recognizes no comprehensive theory of mistake. Consequently, many of the decisions are difficult to reconcile with each other. This difficulty is made worse by the fact that the number of mistake cases is quite small. A further complication is that judges, authors, and lawyers often use different terms to describe the same concept. Mistakes can be either unilateral, a mistake of one party only, or bilateral, a mistake of both parties. In general, the law will only provide relief where the mistake is a bilateral mistake, although there are some important exceptions to this point. The parties may share the same bilateral mistake. It is a common or mutual mistake, or they may each be mistaken, but with respect to a different point. At common law, an operative mistake will render a contract void. In equity, the effect of mistake is said to render the contract voidable. Equity seeks to provide whatever remedy is just in the circumstances. Mistake in equity rendering a contract voidable is, however, doubted in English law at present. Mistake at common law and in equity. The most significant division is between mistake at common law and mistake in equity. We will begin with mistake at common law, because if the mistake is an operative one, the contract is void, and there is no need to consider mistake in equity. Mistakes of law and mistakes of fact. English contract law long barred relief where the mistake was one of law rather than of fact. Absence of genuine agreement. In situations where there is an absence of genuine agreement, the parties are each mistaken, but they do not share a mistake. Their separate mistakes are sufficiently fundamental, however, that no contract can be created. It is sometimes said that the parties are at cross purposes, and that the offer and acceptance do not correspond. No contract can arise if there is an absence of agreement. See Raffles v. Wichelhaus, 1864. Common mistake. Common mistake occurs where both parties to a contract are mistaken about a critical element of their agreement. They share this mistaken assumption. See Bell v. Lever Brothers, 1931. Common mistake deals with those situations where an apparent contract lacks consent, that the apparent consent of the parties is not present and consequently the contract is void ab initio, void from the outset. Mistake operates to disrupt this consensus. It removes any consensus and consequently no contract can arise in the circumstances. Non-existence of the subject matter. In some situations, parties may reach an agreement to deal with a subject matter which, unknown to either party, does not exist. These cases deal with the problem of res extincta. Note that in these cases, the contract suffers from an initial impossibility. See Couturier v. Hasty, 1856, McRae v. Commonwealth Disposals Commission, 1951. Where the subject matter of the contract does not exist at the time of the contract, courts will find that the contract is void. This will not occur where the mistake is brought about by the negligence of one party. Mistakes as to ownership. Like the situation of the non-existent subject matter, these cases involve a situation of initial impossibility. One party agrees to sell and the other party agrees to buy something which, unknown to either of them, is already owned by the buyer. The agreement is impossible to perform because it is impossible to transfer the ownership since the buyer already owns the thing. See Cooper v. Phibbs, 1867, and Bly v. Martin, 1966, mistake as to the possibility of performance. In some circumstances the parties may be mistaken as to the possibility of performance. The parties have a shared misapprehension that performance of their agreement is possible. There are three main categories of cases. Cases of physical impossibility. See Sheikh Brothers Limited versus Oxner, 1957. Cases of legal impossibility. See Cooper v. Phibbs, 1867. Cases of commercial impossibility. See Griffith v. Brymer, 1903. Mistake as to equality of the subject matter. In Bell v. Lever Brothers Limited, 1931, where Lord Atkin wrote the leading judgment, he recognized that a mistake as to quality may render the contract void. Mistake as to quality of the thing contracted for raises more difficult questions. In such a case, mistake will not affect assent unless it is the mistake of both parties, and is to the existence of some quality which makes the thing without the quality essentially different from the thing as it was believed to be. The problem the case creates is that if the mistake was not sufficient in this case, it almost never would be. It is probably for this reason that there have been so few successful mistake cases in later years. In the case of Associated Japanese Bank, International, Limited v. Credit du Nord S.A., 1988. Stein J., as he then was, explained the meaning and application of Bell v. Lever Bros. This is an important case because it provides a comprehensive assessment of contractual mistake. Stein J. stated that the doctrine of mistake at common law had a narrow ambit, and one into which few cases had fallen. To an extent which has yet to be determined, this case is affected by the decision in the Great Peace, 2002. Courts are generally unwilling to find that a contract is void at law where the mistake is the mistake of one party only. To find the contract void would, in most instances, prejudice the non-mistaken party. Accordingly, courts will generally only find the contract void in one of two situations. In the first case, the non-mistaken party is aware of the other party's mistake and proceeds to contract anyway. In the second case, the non-mistaken party has created the mistake to induce the, now, mistaken party to contract. The largest group of these cases are those of mistaken identity. Mistaken assumptions or promises. In some circumstances, mistake is said to negative the consent of the mistaken party so that no contract arises. The mistake prevents the contract from arising. Importantly, the non-mistaken party must be aware of the other party's mistake. See Smith v. Hughes, 1871. Where the mistake is as to an assumption or as to a promise, courts rarely find that the mistake is operative, that is to say, that, because of the mistake, no contract has been created. The entire area displays the extent to which the common law of contract is rooted upon the principle of caveat emptor, let the buyer beware. In some instances, however, it is so readily apparent to the one party that the other is proceeding upon a mistaken basis that the court will find that the apparent contract is void. See Hartog v. Collin and Shields, 1939, and Centrovincial Estates v. Merchant Investors, 1983, mistakes as to identity. This area of law has received recent clarification from the House of Lords in the case of Shogun Finance v. Hudson, 2003. The court is faced with litigation between the deceived and mistaken vendor as claimant and the innocent third party as defendant, in which the claimant seeks the return of his goods. The court must decide which of these two parties will bear the cost of the rogue's deception. In the above circumstances, the rogue induced the contract by a misrepresentation. If the contract is not void for mistake, it is voidable for misrepresentation. However, the vendor must then set aside or rescind the contract before the innocent third party contracts with the rogue. In most mistaken identity cases, the policy arguments will favor protection of the third party. In Shogun Finance v. Hudson, a rogue entered into a written contract of hire purchase with Shogun Finance to purchase a vehicle on credit. The rogue fraudulently assumed the identity of another person. The majority of the law lords found that in these circumstances, identity was critical to Shogun Finance because it was necessary for them to check the credit rating of their potential borrowers. The apparent contract was a nullity due to the mistake of identity and an absence of consensus. The majority also approved of a presumption that in the face-to-face cases the party deceived intended to deal with the person physically before him, and the result is the formation of a voidable contract. Rectification. Equitable relief takes three principal forms. The first is rectification, and this is a remedy which is concerned with correcting a mistake which occurs not in the making of the agreement, but in the recording of the agreement. There is little difficulty in ascertaining the principles of this form of relief. The possibility of rectification exists where a written contract or deed fails to express the common intention of the parties. Even a unilateral mistake may be a sufficient basis for rectification where it is known to the other party and that party fails to draw the mistaken party's attention to it. What is important in relation to rectification is that it exists where the mistake is made in the recording of the agreement only. Because rectification is an equitable device, the usual restrictions as to its application apply. Such restrictions encompass matters such as a lapse of time. A claim for rectification will be barred when a period of time has elapsed, or the intervention of third-party rights. A claim for rectification cannot be made against a bona fide purchaser for value without notice of the mistake, or the conduct of the party who seeks rectification. It is an equitable maxim that he who comes to equity must come with clean hands. Specific performance. It is in relation to the second and third forms of equitable relief that uncertainty exists as to the extent to which there is a doctrine of equitable relief. The second form of equitable relief flows from the nature of the remedy itself. The principal characteristic of specific performance is that it is discretionary, that is, flexible and responsive to the justice of the individual case. Rescission. Equity, historically, could intervene to rescind the contract. Rescission in this context meant that the contract is voidable by the court and not by one of the parties. A court of equity could also rescind the contract upon those terms which the court considered just in the circumstances. It is important to note at the outset that equitable relief will not be available where the party has made a unilateral mistake as to the commercial consequences of the contract he had entered into rather than the terms of the agreement or the subject matter of the agreement. The difficulty stems from working out whether or not equity has any ability to intervene in cases where there is a common mistake, but not one which is of sufficient importance to render the contract void at law. It was in this context that the Court of Appeal gave the decision in the Great Peace, 2002. The Court of Appeal extensively reviewed the cases of Bell v. Lever Bros and Sol v. Butcher. The concept of mistake in equity was considered both before and after Bell v. Lever Bros. Lord Phillips Mr. concluded that it was impossible to reconcile the two cases. Bell v. Lever Bros. Prevailed, Sol v. Butcher was disapproved. The effect of this decision has yet to be determined, and the question of whether or not there is a separate doctrine of mistake in equity has an uncertain answer.
This wasn't so long, was it?